Good afternoon, everyone, and welcome to the July 15th hearing of the Public Service Commission. All right, and we'll pause for a moment for our recorder to get
Yeah, we are on the record.
Yes. Before we get started, I just want to acknowledge the commissioners that are in the room today. Commissioner Wheatley, Commissioner Iori, Commissioner DePrima, and I will ask if Commissioner Richard, who I believe is remote, can acknowledge his presence.
Yes, I'm here. Can you hear me?
Yes, we can. Thank you.
Okay.
All right, so we'll get started with our agenda. The first item on the agenda today is reading of the meeting minutes. Does any commissioner have a change or edits to the meeting minutes? Hearing none, may I have a motion to adopt the minutes.
Move to approve the minutes.
Second.
Moved and seconded to approve the minutes from the last meeting. Any discussion? Hearing none, all those in favor, please signify by saying aye. Commissioner Wheatley.
Aye.
Commissioner Richard.
Aye.
And I say aye as well. So the minutes have been unanimously adopted. Is there anyone from the public who is in the room who would like to make a public comment? I don't see any hands. Is there anyone who is remotely connected from the public who would like to make a public statement? Can you please raise your hand remotely? And I do think I see someone who has their hand raised. So can you unmute, identify yourself, and then make your public comment, please? And I think we would devote maximum 3 minutes for the comments in keeping with the order of the agenda.
Oh, Mr. Chairman, that's probably my hand. The instruction was to raise my hand if I wanted to be heard at some point. So I will lower that so you're not confused. Sorry.
Right. So Commissioner Richard, you will lower your hand. Is there anyone else from the public by raising their hand remotely that would like to make a public comment?
Yes.
All right. So can you please first identify yourself?
Hi, my name is Lisa Rice from Middletown, Delaware. And my comment is based on the Chesapeake Utilities. I am commenting because I don't see how the delivery or the administrative cost, I don't see how you can justify raising the rates based on those things. And to represent the public, I think that we deserve a little bit more information to justify the raise in rates and costs for us. Thank you.
Thank you, Ms. Rice, for your comments. Is there anyone else from the public who would like to make a public comment? Please signify by raising your digital hand. I don't see anyone else from the public who wants to make a comment at this time, so we'll move forward with the agenda. Next item is the consent agenda. Does any commissioner wish to have any item from the consent agenda set aside?
Chair Gray, I would move that consent agenda item number 7 be removed from the consent agenda and moved to the regular docket.
Okay. Any other items from any other commissioner on the consent agenda that should be set aside? Hearing none, seeing none, I'm going to ask if I can have a motion to adopt the consent agenda, please.
Move to adopt the consent agenda with the amendment.
Oh, okay. Are we voting on the one that I moved to be removed?
Yeah, so with the
All right, so let me be clear. Can you state the motion again, please?
Move that the consent agenda be approved and removing item 7, was it? 7 to the regular agenda.
Can I have a second?
Second.
All right, it's been moved and seconded that the consent agenda be adopted with the exception of item 7, which is moved to the regular agenda. Any discussion? Hearing none. All those in favor, please signify by saying aye.
Aye.
I,
Aye. It's been unanimously agreed to move the consent agenda, to adopt the consent agenda and move item number 7 to the regular agenda. So now we move to the regular agenda. Commissioner Iori, can we take up the matter that you have proposed moving to the regular agenda at this time?
Yes, thank you, Chair Gray. I had made some revisions to the proposed form of order. I think in a contested issue of such as, or contested matter such as this, minute orders are a kind of an inappropriate vehicle for, explaining the commission's decision in the matter. It's, I think, more complicated than usually addressed in a minute order. So I had made some revisions that kind of turned it into a hybrid. If I had had more time, I probably would have rewritten it as a full findings, opinion, and order. But in any event, I made some revisions, and then our council made some proposed revisions as well. So we have competing forms of order, and it obviously depends on which of these the commission believes that we, during our deliberations, which more accurately reflects our deliberations. I, of course, think it's mine, but I'm a little biased. So,
All right, so the first statement I'll make is that with our materials that we received in preparation for this meeting, we did get an order number 11037, and that is the order that now has pending 2 proposed sets of revisions. Am I correct? Okay. And so I'm going to lean a little bit more on the legal counsel for the commission in terms of the substantive nature of the changes that have been made. Can you please give us some summary about what, if anything, is substantially different between the order we first received and the revisions that are pending on the table?
So I think with respect to the revisions that Commissioner Iori made, she made revisions, I think, substantially that clarify or specify, make more fulsome the order that was proposed initially, some grammatical items and just maybe explanations as to what certain numbers are, like referring to incremental revenues or the DSIC number, what that constitutes. And then she also included, which is the more, I would say, the substantial edits, I would say pieces of what she shared, if not the full comment that she made during the hearing or the meeting on July 1st about, the financial burdens on that the increased electricity prices imposed on Delaware consumers. She also noted the DPAs and the governor's contentions about this interim rate. And she also, in that, discussed Section 306, and that in her comments, how Section 306 constrains the commission's authority in these circumstances, as 306 is discusses the effective date of rate change for interim rates, which is what this petition is referring to before you. And that's a lot of what I think, and Commissioner Iori, please correct me if I'm wrong in that very short summary. But the Commissioner Iori also, her comments include a summary of, the effect of SB 326, which we know is now signed. And she fleshed out as well the DPA and Delmarva's positions on their disagreement as to what the amount of between like the 50 and the 75% limitations apply. So she fleshes that out as well. There was a small portion of these revisions that Commissioner Iori proposed that discussed whether Section 306 was controlling versus whether Sections 309, 310, and 311 were controlling. And in her comments at the July 1st meeting, she shared her opinion on the tenets of statutory construction as generalized statutes versus specific statutes. And that is where Commissioner Iori and I disagree. So that is where so she had more explanation as to why she thinks sections 309, 310, and 311 do not apply. And my legal advice was that while I did not think I believe section 306 has language that indicates that the interim rates, if certain conditions are met under 306A, then under 306B, the proposed rate, the language specifically includes that the proposed rate change shall automatically become effective. So I do not believe that sections 309, 310, or 311 would halt that process, so to speak, but my opinion differs from Commissioner Iori in that I think section 309, 310, or 311, specifically 310, would be legally permissible. Whether the commission wanted to go down that route and proceed with having a hearing and determining whether there were facts to support a 310 finding is a different question, is a different issue. But legally, I think it's permissible. Commissioner Iori does not. And so that's where my, I would say, brief revision to, on top of her revisions, that's where we differ. I'm not sure, I don't remember there being too much discussion about whether that, on that particular issue at the meeting. I know there was a lot of discussion about the impact on the public, but that's where my comments are coming from. I'm not sure that I answered your question.
All right, I think you've gotten pretty close. Thank you very much for that feedback. And so the question I would ask you as a follow-up is, do you consider the revisions in front of us to be more contextual or more substantive? And I distinguish between the two, as contextual means that you're putting a framework around the rationale for the substance of the order. And the substance of the order is that the interim rates by this commission were decided to be 1/2 of what they were allowed. Have any of the substantive quantifiable numbers changed?
Did the substantive quantify, can you repeat that?
All right, the substantive quantifiable numbers. The interim rate was approved at 50% of what they were allowed. Is that the same in the revised order?
That is the same.
Is it for 7 months and then it moves to 75%? Is that in the revised order? So those are the substantive aspects that I'm asking. Are they the same?
I believe they are the same. I think.
Commissioner Iori, would you agree?
Yes and no. And I think it's because I have a different definition of substantive than you do. To me, substantive isn't just this is the exact issue that we decided, limited to, is it 50, should they be able to implement interim rates? And if so, is it 50% of the total rate change or 70, or of the incremental rate change? To me, substantive also includes the reasons why we voted as we did. So to that extent, I think that both council's changes and my changes add substance to the minute order that was initially provided in our packages.
Right. Just what I was going to say, that substantively, what you just cited, the numbers wise, yes, that's the same, but there is a lot more rationale in,
Okay, so it's a matter of definition. I consider that context. It wraps around the reasons, the basis, the motive, and so forth. But the actual changes that we agreed at the commission for allowing the interim rates is still the same in the revised order. That's where I'm headed.
Yes.
Okay, that's what I wanted to get to. So now my question is, has counsel for the staff, counsel for the public advocate, and/or Delmarva had an opportunity to see this language?
no, they have not.
With all due respect, Chairman Gray, this is the commission's order, and given that the commission, unless the commission votes to enter the original order that we were provided, I don't think we need to circulate it to the parties.
And
Okay.
for what it's worth, I agree with Commissioner Iori. Seeing that this is such a contested matter and you have 3 litigants all have differing opinions on how the order should be written, I think it's best to leave this order being drafted and contested matters going forward, for what it's worth, with the commission.
Okay, points well taken. Although I do seem to recall in the discussions we've had in previous meetings, I believe the utility was to put a schedule together. And so the only reason I ask, have they seen it, is just to confirm that there's been no impact on that schedule that they have presented.
So the utility saw, Delmarva saw the order as originally drafted. I don't know that there was any discussion on your question specifically, with respect to the schedule. I don't see anything in the order that would impact the schedule, though, for what that's worth.
Okay, can I ask, and if she agrees in the context of this discussion, the questions that I'm trying to clarify?
Yes, I would agree with Ms. Sweeney's characterization. The numbers have not changed to my knowledge. I haven't seen the order, but based on the description that's been given by Commissioner Iori and Ms. Sweeney, the numbers have not changed, and Delmarva is the one who provided those numbers for me initially, and they have since filed an updated schedule, and they will have the opportunity after the order is officially signed to bring before the commission any issues they have with the order. So if there are issues with the numbers, then we can address that at a later time.
Right, fair statement. And just before I ask if there are commissioners who have questions, Mr. Tweedy, do you have any questions on this issue as we stand?
No, Your Honor.
All right, thank you. All right, any commissioners have questions or comments? Commissioner DePrima.
First, I want to thank Commissioner Iori for taking this on and putting a lot of context wrapped around the order, and I can't agree more. I hope in the future there will be less reliance on these minute orders, which I just learned for this meeting what that meant. So I appreciate the explanation. For me as a newcomer here, context is really important. And I'm not a lawyer and I've never played one on TV, so it's really hard for me to follow some of this stuff. So I'm just saying that broadly. So I do appreciate it, and I do appreciate you putting a lot of her contextual stuff in your revision. I was on the record at our meeting last time that I believe that the Section 310 and the other related sections are permissible. So I agreed with that. And but I chose not to support going in that direction, and I think it was put as a business decision because of the public notice requirement, because we're in the middle of a case, a hearing on this matter. In short, it would really gum up the works, I think, if we went that route, and I'm not even sure whether we had enough evidence to support it. So the bottom line is, for me, I appreciate the revision that's stamped BRS, I think. And,
For the record, is just my revisions on top of.
right, except
Right.
for the issue at issue is whether you believe, we need to point out 3010 is or is not preventative. I mean, that's the bottom line. And in this instance, I'm supportive of the VRS revisions, but very thankful for Commissioner Iori for putting some more context in there and correction.
Thank you, Commissioner. Commissioner Wheatley?
I have to agree with Commissioner DePrima. I think the effort, though, that was made was very important because this back and forth between the two attorneys have made this much better, to the point that it really now turns on that one issue. And I'm just not ready to say that we don't have the authority because I think we might. The question is always going to be whether or not we should exercise it, which is going to be a case-by-case thing. In this instance, then, I'm supportive of our attorneys.
Thank you, Commissioner Wheatley. Commissioner Richard, do you have anything on this issue?
Yeah, thank you, Mr. Chairman. Yeah, I think this discussion has been helpful. Part of it is just trying to understand what our process is. I was not aware that there was going to be a written order. I thought our discussion last week, which my understanding is recorded, by tape, or what do we want to call the Zoom recording. And it's my understanding we also have a proceeding recorder as well. So it was my understanding that the order stood on its own. I mean, the motion was made, and to the extent that we can just take that motion and then add the vote to it, I think it's great to have this discussion and maybe in the future a written order. But at this point, I didn't know up till this meeting, and I had sent an email around asking what are we voting on today, and if there's going to be a written order, then there should be an opportunity for the commissioners, I think, to see that order before we vote on it. And in many cases, there's an opportunity also to add to our order. If there's going to be, substance added or justifications or explanations of positions, that might be an opportunity for commissioners to weigh in, or in the alternative, to actually provide a concurrence or a dissent. Again, not knowing that this was going to be the process, I opted last week to just go ahead and abstain, because I stated my opinion, my views, and at that point it just seemed like the appropriate course of action. So in any case, I guess I don't object today to accepting this new order, but I'd like to see if we can maybe come up with a process in the future that, again, if there's going to be a written order drafted, that we have an opportunity as commissioners to see what's going to be drafted, add to it, contribute to it, and then potentially we may want to have that opportunity to have a concurrence or dissent. So I'll just add that to this discussion now.
Thank you very much, Commissioner Richard. I understand. So, and thank you. I now will turn to Commissioner Iori, and I'm hopeful that she's prepared to make a motion in this matter. If she has some summary comments prior to that, that would be appropriate as well. Commissioner Iori.
Chair Gray. First of all, Commissioner Richard, this commission can only act by written order. So the fact that we have recordings of what we orally voted on last week, yes, we have to deliberate in public, but we can only act by written order. Yes, I realize that the circulation of the order was not the most opportune. I would have liked to have seen it circulated earlier than it was. That having been said, the commissioners have made clear their decision that they prefer council's draft, and that is fine. I would just note, however, that we will not be able to sign that one today. She is going to need to put some more put a rationale into ordering paragraph 5.
Oh, sorry. I'm happy to do that quickly right now if that's helpful for the commission for what it's worth based on comments made today.
I would offer that the agenda appears to be sufficiently long. You may be able to achieve that today. Thank you.
And I'm sorry for interrupting, Commissioner. Murphy.
However, no, don't apologize. However, I am not prepared to make a motion because I do not believe that our council's, or I did not believe when I drafted it, that our council's revisions accurately reflected what the commission actually voted on last week. So I am not prepared to make that motion.
But let me, for clarification, Commissioner, ask if the council is stepping away to provide the input you have just pointed out, will that bring closure in such a way that you would be prepared to make a motion?
No,
What's missing?
it's not what's missing, it's what's being added. I don't agree that during our deliberations last week, when we voted on this, that we said anything. I know Commissioner DePrima did, but I specifically recall you, Chairman Gray, saying that you were persuaded by my statutory construction analysis. So that does not, so that would make it a 2-2 vote with one abstention. If you were to vote in favor of mine, so
In favor of yours or in favor of council?
in favor of mine.
So
Okay.
Commissioner Richard abstained. And based on what we've heard today, Commissioners Wheatley and DePrima have agreed with, let's just say, my version. So that's 2-2. And I would say that if you are at a tie, kind of like a jury instruction from the court is you'd have to go back and you'd have to maybe tweak this more until it's to your liking that we have a majority.
Right. 1 second, Commissioner. Commissioner Iori, what is the solution beyond the problem statement you have just offered, please?
I do not know. I mean, the solution is that one of us changes our mind.
I wonder
Mr.
though,
Mr.
if,
Chairman,
Just a minute, Commissioner Richard, please. Ms. Sweeney.
just wonder if there is a way to draft, to revise this even more to make it so that everyone is in agreement with it. Maybe not.
I have a proposal. We're already a week behind this. The rates are already in effect based on our oral order. We can kick this to the next meeting and meanwhile, work on language that is satisfactory to all the commissioners
Well,
presented at the next meeting.
one comment, and then I want to go to Commissioner DePrima, who had his hand up first, and then Commissioner Richard. I seem to recall, in terms of the summary vote we took previously, that Commissioner Wheatley also expressed that he was finding your rationale to be compelling. So if that's you, Commissioner Wheatley, and I, how does it get to 2-2?
Because he just changed his mind.
Okay, understood. Perhaps I wasn't listening well enough. All right, so Commissioner DePrima.
Well, as I understand it, before we got into this conversation, I thought we were going to move this further into the agenda, giving some opportunity to make a few amendments. So I was ready to move it on the agenda and give some time, which I still think is appropriate. Quite frankly, and maybe I don't understand the process, if we moved it further down, gave you an opportunity to add some of the context that you wanted to, bring it back to us, and then we vote. It's a democratic process, and I understand there could be a tie, which means we're going to kick the can anyway. And so, I almost feel like this deserves a vote, and if it flies and it sticks to the wall, then great. If not, we're back to postponing it maybe to the next meeting for more deliberations and revisions. That's all.
So the only point of confusion remaining for me then is whose revisions are going to get the energy? Is it the legal counsel's revisions or is it Commissioner Iori's revisions?
Now I think Commissioners DePrima and Wheatley said their comments suggested they were in favor of my revisions, and Commissioner Iori is in favor of her revisions. So
I'm
I think
prepared to
it
make-
depends on
Right.
Chair Gray, your opinion.
Let's pause, please. Commissioner Richards?
Yes, it makes it, this is, we've already voted on this and the company is in compliance. So I kind of feel like we're just now just trying to memorialize what happened. And I understand that, yes, of course, everything has to be memorialized and written. But given that there was, I don't think there was some understanding, at least by me, that there was going to be a process of going through a full written, drafted report that, and having the fact that the commissioners really didn't have a chance to review and provide any input to that. Can I just suggest at this point, why don't we just go to the record? We have I think a written and a recorded, and just write out the motion that was adopted and then just let that stand. And if people want to go to the context and all the other information behind it, they can go to the record. But that way it doesn't seem like we're trying to look back in time or undo what we've already done. But rather let's just put into a motion precisely what was voted on.
Because we're legally required to give reasons for why we voted the way we did.
Well,
So we can't just
stated them.
say, this is how we voted, end of story.
Right.
Okay, well, then we need
Rationale
to
that-
have an opportunity to see a full draft so we can all contribute to that draft. Because there was an active discussion and there wasn't an opportunity then for, our positions to be recorded.
No, I agree. I would have liked to have seen it circulated before it was. So I agree with you.
All right, so the facts are that A, the interim rate at 50% has been approved by the commission. B, I believe it has been implemented by the company. Am I right? By shaking somebody? Yes, okay, that's true. And so if we're looking for more time and opportunity for commissioners to engage on completion of a revised order, then my proposal is going to be that we just pause this matter. We'll take it up in the next meeting and hope that the staff will provide each of us the language that we can react to.
I would respectfully request that this be handled by me as your counsel, as the commission's counsel for this matter, as well as the commissioners. Happy to communicate with folks individually so that we are complying under the FOIA law. I don't believe that having staff involved at this part of the process will be beneficial for reasons previously stated.
Right, and I see Ms. Workman shaking her head to agree with you, and so I yield and agree that that should be the path forward. Now, Commissioner Iori, is that suitable in your judgment for the next steps?
Yes, Chairman Gray, thank
All
you.
right, Commissioner Wheatley had a comment.
It is, however, I do have a comment. And in regard to changing one's mind, that's what people do when they receive additional information. That's what we're supposed to be doing. And if we continue this process, minds may change again.
Well stated, Commissioner. I agree. All right. So I believe by now, please let me just make sure I'm clear. I believe by consensus of the panel, this matter is going to be set on the table, that the commission's attorney, Ms. Sweeney, is going to work on providing us language that we all will have an opportunity to review in advance so we don't get stuck in this same place the next time we convene. Is that a fairly accurate statement?
I believe so.
All right. Did I miss anything, Commissioner Iori?
I don't believe so.
All right. And so I would declare at this juncture, we move to the next item on the agenda. Thank you very much for your contributions, and we'll look forward to hearing from you, I'm sure. All right. So the next item is in the matter of the adoption of regulations for, oh, sorry.
Did you?
Ms. Sweeney, can you weigh in on that?
No, I don't think we needed a separate transcript for each matter. One is sufficient.
Okay. Thanks for it. Thank you. All right. I didn't know whether that was a statutory thing or not. So, and as my colleague says, I'm not a lawyer. So, the next item on the agenda is in the matter of the adoption of regulations for community energy facilities to implement the provisions of 26 Delaware Code 352 and 360 and 26 Delaware Code 1001. 1014 is amended. Open October 25, 2023, PSC Regulation Docket 3013. Ms. Workman.
It's actually Mr. Ferguson.
Oh, Mr. Ferguson, sorry. Mr. Ferguson.
Thank you, Mr. Chairman and Commissioner. Stephen Ferguson on behalf of staff. So, to provide a brief summary, staff filed a petition requesting to reopen PSC Regulation 3013 regarding community energy facilities. The reason for this request is so that the regulation may be updated to comply with two pieces of legislation that were passed by the General Assembly this year. The first is Senate Bill 210 that was signed into law in March, clarifying the statutory definition of a community energy facility in that the point of interconnection is located in the service area of a regulated utility and the facility be interconnected to the electric distribution system. So this change in the law requires an updating of Regulation 3013. Also, there's Senate Bill 321, which recently passed and awaits action by the governor. The main aspect of this bill for purposes of reopening the regulation is the establishment of consolidated billing for community energy facilities. So this means that customers get a single utility bill that includes both the electric service and the community solar subscription charges on the same bill, and the community solar bill credits would also be applied to the same bill. The subscription payments are then remitted to the community energy facility or subscription coordinator. SB 321 provides that consolidated billing be available statewide by October 1st, 2027. And the commission is tasked with adopting regulations to establish consolidated billing protocols to implement this by the date 10/1/27. So staff requests that the regulation be reopened at this time to make the updates needed from Senate Bill 321. I'd also note staff intends to hold at least one public workshop with interested stakeholders to discuss the proposed changes to the regulation prior to publication. And so for these reasons, staff respectfully requests that the commission grant staff's petition and enter proposed order number 11053. Thank you.
Thank you, Mr. Ferguson. Mr. Sweeney, anything from the public advocate?
No objection from the public advocate.
All right. Thank you. Commissioners, any questions?
No.
May I please get a motion to adopt order 11053?
Motion to adopt proposed order number 11053 as submitted.
Second.
It's been moved and seconded to adopt order number 11053. Any discussion? Hearing
Mr.
none.
Chairman?
Yes, Commissioner
Yeah,
Richard.
I just wanted to comment before voting that, I think this is an exciting next step here. I think community solar is really one of those key state policies that help advance clean energy. It's a good approach, an equitable approach to making solar available to all, and it's also a potential help for low income and moderate income households. So, I think this is it's great that we're supporting this today and moving forward as we advance our state's regulations on community solar.
Great. Thank you, Commissioner Richard. Any other commissioner? All right. Hearing none. We'll take a vote. All those in favor, please signify by saying aye.
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 Okay.
Aye. Commissioner Richard?
I said aye.
Okay. It's been moved, seconded, and adopted unanimously, order 11053. Next item on our agenda is hearing in the matter of the application of Delmarva Power and Light for approval of modifications to its gas cost rates. And looks like for the company, Ms. Shen, Mr. Ferguson, Mr. Crumpler.
Good afternoon, Chair Gray and Commissioners. Zishang Shen on behalf of Delmarva Power and Light Company. This is the evidentiary hearing on Delmarva's application for approval to modify its gas cost rates, balancing charge, transition cost adjustment charge, and pressure support fee, as well as make certain changes to its natural gas tariff for the period of November 1st, 2025 through October 31st, 2026. The application was filed on August 28th, 2025. As a preliminary matter, the parties have provided to the Commission a copy of the exhibit log. I also have hard copies of the log and the exhibits themselves if any commissioners need one. Right. The parties have stipulated to the admission of the exhibits into the record, and therefore I would respectfully move the exhibits into evidence.
Any objection?
No objection from staff.
No objection from the DPI.
So admitted.
Thank you. Delmarva calls its first witness, Daniel Curtis, first and only witness, and ask that he be sworn in.
I swear.
And can you please state your name for the record?
Daniel Curtis,
And what is your position?
I'm the manager of gas acquisitions for Delmarva Power.
And what are your duties and responsibilities?
I'm responsible for developing and managing a safe, adequate, and reliable gas portfolio for Delmarva Power's gas cost rate customers.
Mr. Curtis, what is your educational and professional background?
I attended the University of Delaware and completed specialized coursework at the Energy Management Institution with a focus on technical analysis, derivatives trading, and physical natural gas markets. I have over 25 years experience with Pepco Holdings, Delmarva Power's parent company. I joined Delmarva in 2010 as an asset manager and was promoted to my current position in January of 2025.
And were you involved in the preparation of this application?
Yes.
What is the purpose of this application?
The GCR reflects the cost of natural gas that Delmarva purchases for its natural gas customers with no markup or profit to the company.
Did you review the testimony of the witnesses in this application?
Yes.
Whose witness testimony did you review?
For Delmarva Power, Serena Wilson Archie and Bob Cohen. For staff, Isla Causey, and a memo submitted by Jerome Mirzwa of Exeter Associates.
And Mr. Curtis, can you please summarize the application for the commission?
Yes. Delmarva Power filed to revise the GCR demand and commodity charge applicable to service classifications, medium volume gas sales service and large volume gas sales service. Revise and volumetrically applied GCR factors applicable to service classifications, residential gas sales service, residential gas space heating, gas sales service, gas lighting sales service, and non-electing medium volume gas sales service. Approve the proposed balancing charge, transition cost, adjustment charge, and pressure support fee for the November 2025 through October 2026 GCR period, and approve routine changes to leaf numbers 37, 37A, 38, 39, 53, 55, and 59 of the company's natural gas tariff to become effective on November 1st, 2025.
And can you please summarize the proceedings following submission of the application?
Yes, on October 15th, 2025, the Commission allowed the proposed rate and tariff changes to go into effect on an interim basis on November 1st and opened a public comment period. The parties engaged in substantial discovery. Delmarva Power responded to standard interrogatories and additional formal discovery requests from staff and the public advocate. On February 20th, 2026, staff and the public advocate submitted a memorandum from their consultant, Jerome Mirzwa of Exeter Associates. Staff also submitted written direct testimony.
Did any party recommend any changes to the modifications requested in Delmarva's application?
No.
And did Delmarva file a waiver request in this proceeding?
Yes, Delmarva's gas tariff contains a provision that in the GCR period, the rates in effect will result in an undercollection of Delmarva's gas costs by more than 6%. Delmarva must file a request with the Commission to adjust the rate to account for the undercollection. As of the end of January 2026, Delmarva projected an underrecovery of 27.5%. On February 27th, 2026, Delmarva filed a request to waive the tariff provisions to increase the gas cost rate on the basis that the undercollection was driven by low winter temperatures and high consumption that would not continue for the rest of the GCR period, and that the natural gas storage refill season would increase the underground storage inventories. The company also sought to mitigate the impact on customer bills. Following additional productive discussions with Commission, staff, and the public advocate, the parties agreed that an interim modification of the gas cost rate to 20% would only be in effect from May 1st, 2026 through the end of the GCR period, October 31st, 2026. The purpose of this interim modification was to reduce the undercollection balance and reduce the interest expense on the balance. The Commission approved the interim rate on April 22nd, 2026.
And is Delmarva agreeing to continue complying with previous settlement agreements in prior GCR proceedings?
Yes, Delmarva will continue to take steps to mitigate increases in fixed costs when managing its pipeline capacity and storage portfolio. Furthermore, Delmarva will continue to monitor the level of its over and under collection balance to determine whether a change in the methodology used to calculate GCR rates is necessary. Delmarva also agrees to continue to hold quarterly discussions with Commission staff and the Division of the Public Advocate to review the company's collection balances, hedging program, and other topics of interest, such as measures that could be taken to reduce the volatility of the GCR rates caused by amortization of gas costs over and under collections.
And finally, Mr. Curtis, what is Delmarva requesting the Commission order at this time?
Delmarva requests that the Commission approve as final the proposed rates and tariff changes that went into effect on November 1st, 2025, as modified by Commission Order Number 11003.
Thank you. And Mr. Curtis is available for cross-examination.
Any cross-examination? Mr. Ferguson?
Staff.
Mr. Crumbler?
None from the DPA.
All right. Thank you, Mr. Curtis. Yes, Commissioner.
Thank
Sure, go ahead.
you. Hi, Mr. Curtis.
Hello.
Has Mr. Jacoby retired?
Yes.
Oh, lucky him. The increase went from 47.990 cents per CCF to 80 cents per CCF overall, right?
80 cents for the effective period of May 1st, 2026 through October 31st,
Right.
2026.
Yeah. There's nothing in, but I read Delmarva's testimony and there's nothing in it that explains the reasons for such a large increase. Can you just explain briefly what the basis for that big jump is?
It had to do with under collections of the period from November 1st, 2025 through April 30th, 2026.
The entire jump from 47 to 80 was was because of under collections?
It was due to high demand and high gas prices during that period.
Okay. And was there a reason that the gas prices were so high? I mean, was there some sort of natural disaster or something that cut off supply or something like that?
It was due to the extreme cold in the mid-Atlantic during that time.
Okay. Okay. Thank you. All right. Delmarva used 56 CCF as the basis for estimating the impact on customers, correct?
May I advise?
Yes.
Yeah. For the November.
Yes, that's correct.
Okay, and that's the average usage, right? Not winter month usage, right?
That was the rate that was in effect for the entire GCR period from November 1st.
No, I'm not talking about the rate. I'm talking about the usage.
I'm sorry.
56 CCF, that was average usage over the year, not
Yes, that's
winter
correct. I'm sorry.
usage, correct?
Yeah, I'm seeing that now. Yes,
Okay,
that's correct. Average usage.
okay. But that's going to be a lot higher in the winter months, isn't it?
Correct.
Usage?
Yeah, the winter months is 78 CCF.
78 CCF. Did you calculate what the impact would be on customers at 78 CCF?
14%.
14%?
14% of the month.
Okay. Was that in your application? Because I didn't see that.
Just give us 1 second.
Sure.
I don't think it was in the original application, but I think it was calculated subsequently thereafter.
But was it provided, was it publicly available?
Yes, yes, it was publicly available.
It was, okay, and I
Acknowledge.
just missed it. All right. Could I just suggest maybe that in the next GCR application, that winter usage also be what the impact for winter usage would be, provided, as well as average usage? Because I'm not really sure that average usage across the year gives the real, effect of what the increase is going to be during the winter months.
Okay.
Thank you. Thank you, Chairman. I yield back.
You're welcome, Commissioner Iori. Any other commissioners have questions for Mr. Curtis? Hearing none. Mr. Ferguson, you have a witness?
We do.
All right, please proceed. Mhm.
Stephen Ferguson on behalf of staff. Staff also has one witness, Isla Causey. I would ask that she be sworn in.
Yes, I do.
Please state your name and business address for the record.
Isla Causey, 861 Silver Lake Boulevard, Cannon Building, Suite 100, Dover, Delaware, 19904.
By whom are you employed?
Delaware Public Service Commission.
And what is your position with the commission?
I'm a public utility analyst.
And in connection with your employment, have you performed certain review and investigation in this docket?
Yes,
And as part of your duties and responsibilities, on February 20th, 2026, did you file testimony on behalf of the commission staff in this docket?
yes,
And has your testimony been marked and entered into the record of this proceeding as exhibit number 8?
yes, it has.
Did staff retain any experts for this docket?
Yes, Mr. Jerome Mierzwa, MIERZWA of Exeter Associates was retained on behalf of commission staff and the Division of the Public Advocate to assist in the review of the application. In lieu of submitting testimony, Mr. Mierzwa provided a memorandum stating that no changes to the company's proposed rates or the company's gas procurement practices or policies, and policies were appropriate or necessary.
Has Mr. Mierzwa's memorandum been marked and entered into the record of this proceeding as exhibit number 9?
Yes,
Did the parties agree that an interim modification to the GCR was in the public interest?
yes, on February 27, 2026, the company filed a request for a waiver of the requirements of leaf number 35, section XXD of the Delmarva's natural gas tariff, which requires an interim rate modification filing when the GCR under collection exceeds 6%. Staff conferred with the Division of the Public Advocate and Delmarva, and the parties agreed that an interim modification to the GCR would be in the public interest and recommended an adjustment to the temporary GCR rates that were permitted to become effective on November 1st, 2025. The commission entered order number 11003 on April 22nd, 2026, permitting an increase to the GCR for the remainder of the GCR period effective May 1st, 2026,
with proration and subject to refund pending further review and the commission's final decision.
Has order number 11003 been marked and entered into the record of this proceeding as exhibit number 11?
Yes.
Does staff accept the application filed by the company on August 28th, 2025?
Yes.
Ms. Causey, does staff believe that the application is in the public interest?
Yes.
Could you please explain your reasons for this belief?
The GCR is a pass-through of the natural gas commodity cost that Delmarva incurs to provide firm natural gas service to its customers. Staff reviewed the application, supporting documentation, and responses to discovery questions provided by the company, and found that the proposed GCR rates were just and reasonable. The GCR rates were calculated correctly and in accordance with the company's tariff and prior commission orders. Additionally, Delmarva has agreed to continue to comply with the terms of prior settlement agreements. Staff believes that the proposed GCR rates, as revised by order number 11003 and approved by the commission on a provisional basis, should be finalized.
Thank you. Do you have anything else to add to your testimony?
No.
Ms. Causey is now available for any cross-examination.
Thank you, Ms. Causey. Thank you, Mr. Ferguson. Any cross, Ms. Shen? Any questions?
None from the company. Thank you.
Okay, Mr. Crumpler?
None from the DPA.
Okay, any questions from commissioners? Seeing none, hearing none. Thank you, Ms. Causey. Any witnesses from the public advocate?
The public advocate would like to provide a brief comment.
Please, Mr. Tweedy.
Thank you, Chairman. I just wanted to comment on this. I mean, it's obviously our job at the Division of the Public Advocate to represent the interests of ratepayers. This is one of those no-win situations where regional cost pressures are pushing up costs that Delaware customers are paying. But this is a pass-through cost that is a pass-through cost to customers. I just wanted to add a little bit of context. So these changes went into effect in November and then were modified following this winter's cold snap. They increased substantially last fall in November. That was a result of the undercollection that occurred in 2025. Then, because of the prolonged cold snap again this winter, natural gas use spiked, costs spiked dramatically, and there was again an undercollection in 2026, hence the modification. We appreciate the company and staff working with us to try and find the best solution, in our view, to a no-win situation. And we would expect that, because these are regional supply and demand challenges, they are the types of challenges that are going to need policy solutions in addition to anything that we can do in this building. So again, as public advocate for the interests of ratepayers, it pains me greatly to see increases like this, but this is the structure we're in. So thank you.
Thank you, Mr. Tweedy. Any commissioners have comments on this matter before we move forward? All right. We have an order number 11056 pending in front of us. I'm looking for a motion.
I move that order, findings, opinion, and order number 11056 be approved as submitted.
Second.
It's been moved and seconded that the commission adopt order number 11056 as submitted. Any discussion? Audience does not participate in this matter. Sorry. I don't think you have standing. So it's been moved, seconded. I don't hear any discussion from commissioners. So I'll ask for a vote. All those in favor, please signify by saying aye.
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 Aye. Commissioner Richard, did I hear?
Yes, aye.
All right, so it's been moved, seconded, and adopted unanimously. Order number 11056 is adopted. Next item on the agenda is the matter of the joint application of Delaware Electric Cooperative. By the way, thank you all for the testimony you provided in this matter. Next item on the agenda is in the matter of the joint application of Delaware Electric Cooperative and Delaware Power and Light Company to adjust their adjoining retail electric service territories. PSC docket number 26-0524. All right, so who's representing Delmarva? Ms. Shen, I'm sorry, I didn't see you move over there. Ms. Shen, would you like to open this matter?
I actually think Mr. Nutter would probably open this item. Thank you.
Okay, welcome, Mr. Nutter. Please identify yourself.
Good afternoon, Mr. Chair and members of the commission. James Nutter with Parkowski, Girk and Swayze on behalf of Delaware Electric Cooperative. Before the commission is in this docket is 260524 is a joint application by Delaware Electric Cooperative and Delmarva Power and Light Company to adjust our adjoining retail electric service territories as to property in Sussex County, which I'll refer to as the Azalea Woods community. We have prepared for the commission a list of stipulated exhibits. They would include Exhibit 1, the joint application that was filed with the commission in this docket on May the 12th, 2026. Exhibit 2 would be Exhibit A to that joint petition, which is a map showing how the existing service territory boundary with respect to that community is split between Delmarva Power and Delaware Electric Cooperative. Exhibit 3 would be Exhibit B to the joint petition, which is a map showing the service territory to be acquired by Delaware Electric Cooperative under the joint petition. Exhibit number 4 would be the consent of the property owner, Azalea Woods LLC, to the service territory boundary adjustment. And Exhibit 5 would be Delmarva Power's letter docketed in this matter, consenting and acknowledging the service territory adjustment. And that deck will be, if the petition is approved, the deck will be assuming the electric service territory in the Azalea Woods community.
I'd like to have those exhibits admitted, yes?
Yes, sir, and I have a copy for the court reporter.
Right, that's fine. Any objection to the admission of these documents?
No objection from staff.
Right, the exhibits are admitted. You can continue, Mr. Nutter.
Thank you, and Delaware Electric Cooperative would like to call its first witness, Troy Dickerson. Ask that he be sworn.
Yes, I do.
Can you please state your name and where you are currently employed?
Troy Dickerson, and currently employed at Delaware Electric Cooperative.
And how long have you worked at Delaware Electric Cooperative?
Coming up on 15 years.
What is your current position with Delaware Electric Cooperative?
Currently, I am the Vice President of Engineering.
And as Vice President of Engineering, what are some of your job duties and responsibilities?
So it's the entire engineering department, substation, system protection, purchasing of all material to build new lines and things like that, our cable locators and GIS department.
And do your job duties as Vice President of Engineering also include system design and infrastructure planning for new services?
Yes.
Are you familiar with the Azalea Woods community?
Yes.
Can you tell the commission where that community is located?
So that community is located east of Georgetown, just off of Route 9 on Gravel Hill Road.
Is it a single-family residential community?
Yes.
How is the service territory for that community currently divided between Delaware Electric and Delmarva Power?
So currently the service territory line runs north to south, where DEC is serving the eastern side of the service territory boundary line.
And does Delaware Electric Cooperative currently have existing customers that it is already serving in the Azalea Woods community?
Yes, we're currently serving about 40 to 50 meters within Azalea Woods now.
To your knowledge, does Delmarva Power, with respect to the area of the Azalea Woods community and its service territory, have any energized customers or is currently serving any active customers?
No, they do not.
And are you familiar with the joint petition filed by Delaware Electric Cooperative and Delmarva Power and Light requesting that the Public Service Commission approve a service territory modification that will allow Delaware Electric Cooperative to serve the entire Azalea Woods community.
Yes.
Can you briefly describe how Delaware Electric Cooperative will extend its distribution service to serve the entire community and what upgrades may be required?
So no upgrades will be required, but since we're currently serving Azalea Woods, we would just extend our primary lines into the additional phases that we would be picking up from the territory boundary change.
Is Delaware Electric Cooperative, in your opinion, as the Vice President of Engineering, able to provide safe, reliable, and adequate service throughout the entire Azalea Woods community?
Yes.
Will extending service, Delaware Electric Cooperative service, or any upgrades required to serve the entire Azalea Woods community cause any impairment in the service Delaware Electric Cooperative provides to its existing customers?
No, it will not.
And are you familiar with the developer of the Azalea Woods community?
Yes, Natalian Communities.
And have you worked with them with respect to a plan of service to serve the entire community?
Yes, we have.
And to your knowledge, has the developer requested Delaware Electric provide service to the entire Azalea Woods community and consented to the service territory adjustment?
Yes, they have.
And have you also been in communication with Delmarva Power regarding the joint petition?
Yes.
And to your knowledge, has Delmarva Power also consented to the service territory adjustment to allow Delaware Electric Cooperative to serve the entire Azalea Woods community?
Yes, they have.
And do you believe that the proposed service territory adjustment is in the public interest?
Yes.
Those are all the questions I have, Commissioners. If I tender Mr. Dickerson for cross-examination.
Thank you, Mr. Nutter. Any cross?
No questions from staff.
None from the DPA.
Okay. Any questions from commissioners? None. I do have one question. I'm not sure I heard you mention, but roughly how many customers are impacted by the territory change?
There are no existing customers that are being transferred, if you will. This is all undeveloped land on the Delmarva side. The total community is about 610 lots.
Okay, that's a fair response. Good. Ms. Shen, do you have anything else to add to this matter?
No, as iterated by Delaware Electric Cooperative, Delmarva supports this territory adjustment and appreciates the work together. Thank you.
Thank you very much. All right, Commissioners, so we're sitting with proposed order number 11036 in front of us on this matter. I'd like to ask if I have a motion with regard to that order.
I'll move that we approve proposed order number 11036 as presented.
Second.
So moved and seconded to adopt order number 11036. Any discussion? Hearing none. Those in favor, please signify by saying aye.
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 Commissioner Richard as aye. So it's unanimously adopted order 11036. Thank you very much, gentlemen. Thank you, Ms. Shen. Next item on the agenda is in the matter of the application of Chesapeake Utilities for approval of a change in its gas sales service rates, GSR, to be effective November 1st, 2025. Docket number 25-0834. Good afternoon, Mr. O'Brien.
Good afternoon. Thank you, Chair Gray and Commissioners. Bill O'Brien on behalf of Chesapeake Utilities. As you're aware, this is the evidentiary hearing on Chesapeake's application for approval of a change in its gas sales service rates and a change in its transportation balancing rates. The GSR is an annual cost recovery mechanism for Chesapeake's gas supply, just like the GCR set out for you by Delmarva Power a few minutes ago. This application was filed September 2nd of last year and has gone through the typical robust GSR procedure, including extensive discovery from staff from DPA with the assistance of their expert gas supply consultant. As you heard earlier, the GSR is a dollar-for-dollar pass-through of the cost to the company of purchasing the natural gas commodity, and the cost of transporting the gas by interstate pipeline to our distribution system. So contrast the GSR with our distribution rates or delivery rates, which are approved in a base rate case and which include a return on investment. We also file an annual gas supply plan, which is described in our GSR testimony and which is reviewed annually as part of this proceeding by commission staff and the public advocate, and of course, their gas supply expert. The commission should have the exhibit log listing 6 exhibits. It's my understanding that all parties agree that the exhibits on the exhibit log are admissible, and therefore I would like to offer those exhibits into evidence.
Any objection?
No objections from staff.
None from the DPA.
All right. Exhibits are admitted. Thanks.
Thank you, Chair. The company calls its first and only witness, Michael Reno, and asks that he be sworn.
I do.
Please state your name, business address, and position with Chesapeake.
My name is Michael Reno. My business address is 500 Energy Lane, Dover, Delaware. I am a regulatory manager with Chesapeake Utilities.
Have you testified before this commission in any prior cases?
Yes, in last year's energy efficiency rider proceeding, which was docket number 25-0334, and our last base rate case, docket number 24-0906.
Please summarize your background.
I received a bachelor's of accounting from Delaware State University in 2016. I have been employed with Chesapeake since 2017. I work in the corporate finance department, working in various finance roles. In 2019, I joined the regulatory affairs department as an analyst. In the regulatory affairs department, I have served the various regulated business units under Chesapeake Utilities Corporation. My duties have included establishing new regulatory programs, attaining commission approval for capital projects, and preparing of routine and non-recurring special projects, including rate case proceedings. In 2025, I was promoted to regulatory manager.
What has been your assignment in this docket?
My assignment in this docket was to present and discuss the calculation of Chesapeake's proposed gas sales service rates to be effective for service rendered on or after November 1st, 2025. I also reviewed and proposed the final order in this case as recommended by all the parties.
In connection with that assignment, did you help prepare and file on September 2nd, 2025, an application for approval to implement a new rate under the company's GSR tariff provisions?
Yes.
In connection with that assignment, did you submit your own pre-filed testimony in this case, consisting of 29 pages of testimony, together with 15 schedules? And for purposes of this proceeding, are you adopting the pre-filed direct testimony of Michael Salasa, manager of energy logistics for the company, consisting of 10 pages?
Yes.
So that would be your direct testimony admitted into evidence as exhibit number 2, as well as Mr. Salasa's direct testimony, which is exhibit number 3.
Yes.
If I were to ask you today the questions set forth in those pre-filed testimonies, would your answers be the same?
Yes.
Is the information set forth in the application, the schedules to the application, and the pre-filed direct testimony you've adopted true and correct to the best of your knowledge?
Yes.
Is Chesapeake's application in conformance with earlier GSR settlement agreements?
Yes.
In particular, does the application comply with the new requirement from last year's GSR settlement, whereby the company agreed to adjust the methodology for calculating its balancing service rate for its transportation customers?
Yes, with this application, the company established a mechanism to reconcile projected and actual transportation balancing service revenues and costs on an annual basis and adjust future balancing charges to collect or return any cost or under collections or over collections similar to the existing GSR true-up.
And in connection with your assignment, did you prepare and file updated tariff sheets in October of 2025, converting the per CCF GSR rates from the application to per therm rates, as well as applying the GSR to the company's new rate classes in compliance with the commission order approving the settlement from Chesapeake's recent base rate case?
Yes, that would be Exhibit 4 in this proceeding.
And in connection with your assignment, did you prepare new tariff sheets incorporating a 10-cent per therm increase to the interim GSR rates with a proportional increase to the high load factor service GSR based on an agreement with staff and DPA in order to reduce the GSR under collection in compliance with tariff sheet 7.300.
Yes, that was approved by order number 10992 dated March 25th, 2026.
All right, you mentioned earlier that you've reviewed the proposed final order in this case.
Yes.
Please summarize the terms of the proposed order as agreed to by the parties.
The parties agreed to the company's proposed GSR and bouncing service rates as set forth in the application effective November 1st, 2025, as converted to the per therms rates and as adjusted by order 10992 in March. The rates are subject to true up with our 2026 GSR application. In addition, the company agreed to the terms we agreed to in earlier settlements as outlined in paragraphs 21 through 24 of the proposed final order.
Do you believe that the terms of the proposed final order are just and reasonable and in the public interest?
Yes.
Thank you, Mr. Reno. I have no further questions at this time. Mr. Reno is available for cross-examination or any questions from the commissioners.
Thank you, Mr. O'Brien. Mr. Reno, any cross?
No cross from staff.
None from the DPA.
Thank you very much. I think next in this matter, sorry, go ahead. Yes, Commissioner Iori, please.
Hi, Mr. Reno. Many of us commissioners are new, so I can't profess any familiarity with the settlement agreement in the last base rate case. So what was the purpose of changing from CCFs to therms?
If the chair and commission please, I can give a high-level explanation of that.
Please, Mr. O'Brien.
Therm billing is becoming more and more common in the industry, and Chesapeake Utilities Corporation does do therm billing in its other business units and other states. So in order to align better with our internal operations, we ask that we convert to per therm billing. Therms are based on the heat content of the gas, so it's actually a more accurate way of billing. CCF is purely volumetric, and as you know, we're bringing up gas from the Gulf Coast as well as the Marcellus Shale region, and that gas sometimes runs hot and other times doesn't run as hot, meaning higher thermal content versus lower thermal content. So with higher thermal content, you need less volume to run your appliances. So if we base the rates on therms, it actually comes out more accurate in our view than just CCFs. And in order to reflect the changing nature of the thermal content of the gas that's delivered to our system, we make a periodic adjustment to reflect that, and we file those numbers with staff in the DPA.
Okay, so does that have an effect on the price of the gas? The heat content? I apologize if I'm showing my ignorance, but.
Well, no. It would have an effect if you look at it just on a volumetric basis, but the value of the per therm billing is that it takes that one variable out. And so to answer your question, it means there's less of an effect on what people are paying because it's more consistent based on what they're actually getting through their meter.
Okay, thank you.
Just a follow-up, Mr. O'Brien. So the periodic adjustment you make that you mentioned, is that an adjustment of the price per therm? Because
it's an adjustment.
It seemed to me that the therm would be the actual base unit.
Right. And you are correct. It is not an adjustment to the price per therm because that is the real price. What it is an adjustment between the measurement in CCFs from the meter to the number of therms that we're billing.
Okay, so what you're doing is you're adjusting the volume or the concentration of therms in a unit volume, meaning that the therms can be higher or lower depending on what your supply source is.
Exactly.
Right. So we had a discussion around this in a prior meeting, and I do recall asking if you were putting conversion information on the bill because the customer is only able to read their meter in CCF, not in therm. And so are you keeping an equation on the bill that allows the customer to make conversions so that they can monitor their meter and their consumption?
Yes.
Okay, good. That's helpful to know. Appreciate it. Any further questions from commissioners? Okay, I think I will turn now to is it Mr. Ferguson, Ms. Workman?
Ms. Workman.
Ms. Workman, please. Thank you for staff.
Thank you. Staff would like to call its first and only witness, Ms. Klashana Marshall, and ask that she be sworn in. Please state your name and business address for the record.
Name is Shauna Marshall at 861 Silver Lake Boulevard, Cannon Building, Suite 100, Dover, Delaware 19904.
By whom are you employed?
The Delaware Public Service Commission,
What is your position with the commission?
Public Utility Analyst.
In connection with your employment, have you performed certain review and investigation in this docket?
Yes, I reviewed the application, testimony, schedules, data requests, hedging plans, and orders issued for prior GSR dockets.
Did staff retain any experts for this docket?
Yes, Mr. Jerome Mearswa of Exeter Associates was retained on behalf of staff and the DPA to assist in the review of this application.
Do you have any changes to your pre-filed testimony?
No,
Were there any public comments received for this docket?
no.
Can you give a brief summary of Mr. Mearswa's analysis?
Yes, Mr. Mearswa evaluated the proposed rates, its basis and reasonableness. He also evaluated Chesapeake's natural gas procurement policies and practices. He reviewed the application, Chesapeake's 2025 long-term gas supply and demand strategic plan, and participated in the discovery process. Ultimately, he determined that Chesapeake's rate and procurement process were appropriate and did not require any changes this year.
Do you agree with Mr. Mearswa's analysis?
Yes, Mr. Mearswa has assisted the PSC and staff in evaluating Chesapeake's annual GSR applications for approximately 14 years now. Staff agrees that the proposed GSR rates are just and reasonable. They were calculated correctly and are in compliance with the company's tariff. Therefore, staff respectfully recommends that the commission approve the GSR as filed.
Thank you. I have no further questions for Ms. Marshall. She's available for cross-examination.
Any cross, Mr. O'Brien?
No cross, thank you.
Mr. Crumpler?
None from the DPA.
Mr. Crumpler, do you have a witness or a statement?
Unless.
Mr. Sweetie?
I would just offer a very similar statement to the statement I made for the Delmarva gas cost rate. This is the same issue, obviously different utilities and slightly different, amounts and impact, but the basic issue is the same. These are pass-through costs over which the cost has gone up based on the very cold winters or cold snaps this past winter and the one before. And the company had made that adjustment in November and then modified it based on this winter. So again, it's a brutal situation for customers, but we don't oppose and we appreciate the company working with us on it.
Thank you, Mr. Sweetie. So, commissioners, any further comments or questions on this matter?
Yes, Mr. Chair, may I be recognized?
Commissioner Richard, please.
Yeah, I thought I just asked this question once since we had two pass-through true-up proceedings today, our hearings today. This is really for staff and for DPA. I'm just interested in the gas supply planning process. It sounds like this is something that is done annually. I just wanted to find out if you could give me a little more color on what happens and how you go through, overall procurement practices, mitigation, hedging processes and procedures. And, just a little bit what goes into, again, the, planning for each winter season.
Is this question, Commissioner Richard, for Mr.
I
O'Brien?
thought I would just do it at this point for both DPA and for staff. I'm guessing that they lead this the gas supply planning process, and that it maybe I'm wrong. Is there an annual I don't know if it's a proceeding or just something that staff and DPA pulled together with the gas utilities for planning for the season, winter season.
Just a moment. I think they're conferring now. So I don't know who wants to take this, Ms. Workman, I guess.
Yes, so most
weigh in?
of those analyses are done by the consultant, Mr. Mierswa, and he is on Zoom right now. If he is available to answer that question for staff, you may want to ask it again. Well, let's confirm that he's available.
Right, just a moment before I do that. Mr. Tweedy, do you have any initial reaction to Commissioner Richards' question?
No, I'll defer to Mr. Mierswa. I mean,
Yeah, Mr. Mierswa is the our expert witness for both staff and the DPA, so he would be much better able to answer that question for you.
All right, we'll hold that thought for a minute. Ms. Davis, did you have something?
So I can say just about the process. It is required by commission order and the tariffs of the utilities that they adjust the gas cost rates or gas sales rate every year with an effective date of November 1st. So this is something that we do regularly, which is required by tariff and commission order.
Okay, that's addressing the price. I think Commissioner Richard was interested to understand the strategy of supply. I don't know if Mr. Mierswa is tied in. Can you perhaps unmute him so that we could get maybe a 3 to 5 minute summary?
Yeah, can you hear me?
You have the floor, sir. Thank you.
Can you hear me?
Yes, we can.
Okay, great. Yeah, I mean, there's many aspects that of what I basically look at is the gas supply planning process and procedures, and there's a whole host of things that we look at to make sure that what the companies are doing is minimizing their gas costs, and to do that, we respond to there's an RFP that is sent out by staff that has a whole list of things, and it's probably the easiest if I just go through that we would look at both companies to make sure that they're minimizing their gas costs for ratepayers. I mean, one of the tasks is make sure that they're forecasting demand requirements correctly. If you don't, it's hard. You're not going to minimize costs if you have a forecast that's inaccurate, because you would be securing resources to meet an inaccurate requirement or forecast. We look at whether the companies have acquired a reasonable amount of pipeline capacity to make sure that they have enough to meet cold conditions, really design day cold conditions, and they don't have too much, and whether they've selected a design day criteria that's appropriate and reasonable. We look at the mix of resources that the company have acquired. Those resources would be, interstate pipeline transportation, storage service, and peaking supplies. And also look at whether the companies have incurred any have acquired any liquefied natural gas supply, and whether those costs are reasonable and whether it is reasonable to acquire those supplies. We also look at the utilities' utilization of capacity release, where they temporarily release capacity to a third party that pays them for that capacity, and then get those payments are credited to GCR customers. And for Delmarva, they also engage in off-system sales, making sure that to sales that are non-GCR customers, making sure that those sales are reasonable and not adversely affecting GCR customers. And what else is there? because, those revenues are generally credited, off-system sales revenues are generally credited to GCR customers. We also look at the level of loss unaccounted for gas experienced by the companies and make sure that those levels aren't unreasonable and aren't readily increasing, because that, that adversely affects ratepayers. We look at their hedging activities to make sure that they're doing a reasonable job of hedging their gas costs so that to minimize, to the extent possible. Well, it's not possible to totally minimize fluctuations in prices, but trying to minimize those fluctuations. We look at whether the transportation services that the company provides to certain customers who buy their gas from third-party suppliers is not adversely affecting GCR customers. Offhand, those are the major areas. I'm probably forgetting one or two minor areas, but those are the major things we look at. It's to make sure they're minimizing the cost of gas for ratepayers.
Great. Thank you. That was exactly what I was interested to hear. As you're probably, very well, some states actually, the commissions hold hearings annually just to kind of review planning, and then also how gas utilities in their state are doing as far as these strategies to try to control cost, or be have more control over the costs of the supply. Obviously, it's a lot isn't in forecasting, and the Mid-Atlantic's a tough place. So overall, it sounds like you're the man, that the professional that does this for Delaware. Do you provide this service for all of our gas utilities?
I provide it for these two. I think that's all you have.
Okay. Well, I'm sorry. Yes. And generally, now that we're at the end of the heating season, how are our utilities doing as far as just best practices? And do you have any ability to kind of rate our gas utilities, as far as these best practices and how they're doing in our region?
They're doing a reasonable job. I mean, if they weren't, you would have seen me file testimony.
Terrific. Okay, good to hear. Okay, well that's really all I had. I have. Thank you, Mr. Chairman.
Thank you, Commissioner Richard. Thank you, Mr. Muzwa, for that input, that information. Any other questions or comments from the commissioners? Hearing none, we have now before us order number 11057. Can I have a motion?
I'd like to make a motion that we approve proposed order number 11057 as presented.
Second.
So it's been moved and seconded. The commission adopt order number 11057 as submitted. Any discussion? Hearing none. All those in favor, please signify by saying aye.
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 All right. It's been unanimously adopted, order number 11057. All right, folks. At this juncture, thank you very much, Mr. O'Brien, Mr. Reno, Marshall. We're going to take the seventh inning stretch, or should I say the hydration break or the halftime. We're going to come back in exactly 10 minutes.
Thank you.
Thank you. All right, let's take a pause. We're going to get our
Great.
That's quite all right. The bane of modern technology. When it works, it's great.
Well, they're working on battery technology all the time now.
Yep.
Can't wait to hear more.
On the hearing agenda, and I think Mr. O'Brien is ready to present.
Thank you, Chair Gray and Commissioners. Bill O'Brien on behalf of Chesapeake Utilities. As you're aware, this is the evidentiary hearing on Chesapeake's application for approval to change its Energy Efficiency Rider Rate, or EER. The rider is the cost recovery mechanism for Chesapeake's energy efficiency portfolio, which is the state's first ever natural gas energy efficiency program. The Commission approved this portfolio of programs in May of 2024 after Chesapeake completed the vetting process with the Delaware Energy Efficiency Advisory Council, or EEAC, in 2023. While staff agrees that the EE rider itself was calculated correctly, staff is recommending discontinuation of the 3 approved energy efficiency programs as of today. That is why you have 2 proposed orders in front of you, both numbered 11054. The company's proposed order simply approves the interim EER as final, with the current programs continuing under the established process until the end of the current cycle, which concludes December 31st of this year. The company, staff, DPA, and DENREC are currently working together on the next 3-year portfolio, which, if supported by the EEAC and approved by the Commission, would begin in 2027. Staff's proposed order, on the other hand, stops short of finalizing the interim rate for the current programs, but continues the rider until the expenses incurred to date are recovered. The order would discontinue the programs as of today, which means the company would not get cost recovery via the rider of any expenses incurred for the remainder of the year. The Commission should also have an exhibit log in front of you listing 5 exhibits. The 5 exhibits are the application itself, the written direct testimony of company witness Jeffrey Weiss, staff's memorandum to the commission dated May 28th, and a letter of support from Drew Slater, Director of Energize Delaware, or the SEU, who is Chesapeake's partner in these energy efficiency programs. It is my understanding that staff and DPA agree that the exhibits on the exhibit log are admissible, and therefore I would like to offer those exhibits into evidence.
Any objection?
No objection from staff.
None from the DPA.
Excuse me, Mr. O'Brien. I'm going to pause here for just a moment to recognize Commissioner DePrima.
Just so everybody knows, I'm going to recuse myself from this hearing. I think you're going to learn that the Sustainable Energy Utility is a partner in this program, and I still have a lingering financial relationship with them. So I'll take a seat in the audience. Thank you.
Thank you, Commissioner. You can proceed, Mr. O'Brien.
Before we get to our first witness, or only witness, I should explain that we're not intending to go into detail regarding the reasons for the current programs falling short of anticipated participation levels or they're not reaching cost effectiveness. You do have Mr. Slater's letter, which provides support for continuation of the programs and explains some of the challenges experienced with these programs. My understanding is that Mr. Slater is remotely in the meeting at this time, but he's not planning on making any comments, but I believe he's there for questions if needed. I should also point out that in his letter and in discussions with the company, Mr. Slater offers to use SEU funding for all expenses incurred for the remainder of the year should the commission select staff's proposed order over the company's. The company calls its first and only witness, Jeffrey Weiss, and asks that he be sworn.
Yes, I do.
Please state your name, business address, and position with the company.
My name is Jeffrey Weiss. My business address is 500 Energy Lane, Dover, Delaware, 10904. I'm a regulatory analyst with Chesapeake Utilities.
Have you testified before this commission in any prior filings?
Yes, I provided testimony in Chesapeake's most recent application before this one for approval of its environmental rider rate, docket number 25-1208.
Please summarize your background.
I received a Bachelor of Accounting in 2007 and a Master's of Business Administration in 2009 from Wesley College. I have been employed with Chesapeake since 2007, serving in multiple roles. Most recently, I was hired in June 2025 as a regulatory analyst with the primary responsibility of handling regulatory filings, routine and non-recurring special projects, rate case proceedings, etc. for Chesapeake's Delaware Natural Gas Distribution Division.
What has been your assignment in this docket?
My assignment in this docket was to help with the calculation of Chesapeake's proposed energy efficiency rider rate to be effective for service rendered on and after May 1st, 2026.
In connection with that assignment, did you help prepare and file on April 13th, 2026, an application for approval to implement a new rate under the company's EER tariff provisions?
Yes.
In connection with that assignment, did you submit your own pre-filed testimony in this case?
Yes.
If I were to ask you today the questions set forth in your pre-filed testimony, would your answers be the same?
Yes.
Is the information set forth in the application and the schedules to the application and the pre-filed direct testimony true and correct to the best of your knowledge?
Yes.
So speaking slowly for the court reporter, can you describe how the EER calculation is made?
Yes, the EER recovers the cost associated with Chesapeake's 3 approved residential energy efficiency programs, which are each implemented in partnership with the SEU or Energize Delaware. For a project year, recovery is based on the approved budgets and forecasted sales amortized over 3 years. The annual calculation also includes a true-up for any over-collection or under-collection from the prior year. This calculation is described in more detail in my written testimony.
Do you believe that the proposed EER rate of $0.0116 per therm was calculated in conformance with Chesapeake's tariff at rate schedule EER and the Commission's order number 10441 approving the EER calculation.
Yes.
What impact would the new EER rate have on a typical residential customer?
The average residential heating customer using 700 therms per year will experience an annual increase of approximately 0.034% or 45 cents. During the winter heating season, an average residential heating customer using 120 therms per month will experience a monthly increase of approximately 0.05% or 8 cents.
So that would be the impact of the proposed increase to the rider. What is the impact of the entire EER rate of $0.01116 per therm?
For a typical residential customer, the entire EER rate averages 65 cents per month.
Thank you, Mr. Weiss. I have no further questions at this time. Mr. Weiss is available for cross-examination or any questions from the commissioners.
Any cross?
No cross from staff.
None from the DPA.
Any commissioners have questions? Mr. Wheatley.
I just was a little puzzled at your kind of preemptive statement of the one question that I had, which is, why isn't this program working any better than it is? Because that's really what we're talking about here. And you said you weren't prepared to go into that, so that's my question. But it sounded like you were saying you weren't going to go there.
Well, there are some reasons provided in Mr. Slater's letter. One reason we don't want to go there is that, the commission's memo and proposed order, the commission staff's memo and proposed order isn't laying blame on anybody. So we don't feel that we need to justify how the program's been implemented. And we do have our partner, Drew Slater, on the phone who could answer questions. I could go through some things that my understanding on why the participation levels have fallen behind what was forecasted, if you would like. But we have our proposed order, but we're not planning to litigate anything against their proposed order.
The reason I'm asking this is that I personally don't want to see the program go away. I think, I understand where the staff is coming from, but I'm thinking to myself as a ratepayer, as a person who is interested in energy efficiency and conservation, that is now really the time to discontinue those efforts. And but given the staff's position on the matter and seeing what appears to be the problem to me is underutilization, that the program's not being used. If this commission were to decide to something different than what the staff is recommending, what are you going to do to increase the utilization of this program so that we don't have to have this discussion again?
These programs, just for a little bit more background, these programs do end on paper at the end of this year. The commission will have another opportunity to see what improvements may be put into place for the next round, the next 3-year cycle. Mr. Slater is on the phone, I believe, but there are a couple of reasons I can just provide to you from a high level. There were some reporting issues regarding participation by Chesapeake customers, so there was some underreporting taking place. You're going to hear a little later today about Delmarva's Summer Relief Program, which provided $500 grants to people I believe it's income eligible, but they had to agree to a home energy counseling checkup, meaning those contractors in the region were drawn towards that program and were not available as much for Chesapeake's program. Those are a couple of the high-level issues around this. There's the question of whether a commercial and industrial program would have been helpful to the cost effectiveness of the entire portfolio. We did have one that was recommended by the EEAC, but it didn't make it through the commission process. We've been working on another one that may be proposed with our next cycle.
If Mr. Slater wants to join in, please feel free.
Commissioner, I'm pending the invitation to Mr. Slater on your question, but before I go there, I think I want to go to staff, Ms. Workman, and have her bring the staff's position into the conversation. Mr. Slater, if you can just patiently hang on for us, I'd appreciate it. Workman?
Thank you.
Yes?
May I ask a question of Chesapeake before
Sure,
we move to
please.
staff?
Yep.
Thank you. One moment, let me, if I heard correctly, you're not taking issue with staff's conclusion that these programs are not cost effective under the TRC test, correct?
Correct.
Okay, thank you.
Thank you, Commissioner Iori. So, Ms. Workman, would you please?
Mr. Chair, may I just ask one question too of the company? I was just interested in the EER. I think you talked about what goes into that. Is there a shareholder component, shareholder return component to that EER?
No.
Let me, Commissioner Richard, for my clarification, you asking, is there a return on investment affiliated with the program?
Yeah, exactly. Is there, I mean, does the company, for funds it spends, is there a return at all to the shareholders?
Thank you, Commissioner Richard. Let me explain a little bit more. In many ways, it's much like the gas cost recovery, where we track actual costs and actual revenues, and then there's a true up each year. But because of the long lead up to the programs making it through the EEAC, making it through the commission, and the costs that were incurred prior to approval, the commission several years ago approved a regulatory asset for some of the startup costs, the design costs, the development costs of the programs. As part of that reg asset, there was a return authorized at the company's authorized cost of debt, which, as you know, is below the rate of return authorized in rate cases and actually below the return on equity determined in rate cases. So to the extent you consider a cost of debt return on a fixed bucket of costs, which was that regulatory asset that was already approved, then that would qualify, I suppose, as a return on a portion of the cost recovery.
Clarification.
That was exactly the question I was asking. Is there a return of and return on? It sounds like there is a small return on the. Okay, thank you.
Is that what I would describe as a carrying cost as opposed to a return on investment?
Yeah. Some states, I know the Maryland Empower for a long time it was a full rate of return, but this is just cost of debt. So thank you. That answered my question.
Thank you, Commissioner Richard. Any further questions?
Yeah.
Okay, so I'd like now to turn to Ms. Workman. Thank you for your patience.
Of course. Staff's position is set forth in Ms. Marshall's memorandum, which is been entered into the record at Exhibit 3. But very briefly, the programs do not meet, or the program doesn't meet the total resource cost test. And so it is staff's opinion that ratepayers should not be the ones who bear the burden of this program because it doesn't meet that test.
I'm not sure I'm familiar with the total resource cost test. Can you briefly, for the benefit of myself and the other commissioners on the panel?
Ms. Marshall is
Describe it.
going to be able to answer that for you.
Thank you very much, Ms. Marshall.
She needs to be,
Sorry.
she
And it
needs
was
to be sworn. No.
for another case.
Sorry.
Yes. When it was approved by the Senate, a part of that approval process is it does have to meet EMNZ. And they have a calculation, which is the total resource cost as far as cost benefit and cost effectiveness of the programs. Each program itself has to meet a 1.0 TRC calculation, as well as the entire portfolio has to meet the 1.0 TRC. For these particular programs, they have not been able to meet that. And that's actually a part of the legislation and being able to approve the program. They actually have to have that in order to be approved. That is actually written in the bill. And because they do not meet the criteria that we would be able to support in approval through the recommendation to the commission.
Okay, thank you, Ms. Marshall. But do you have specifically what the TRC is? You said it's not one, but that doesn't tell me what it is.
I can't tell you what it is exactly. I can tell you the criteria that they would need to meet in order to hit the TRC. I can tell you off the top of my head what it is.
Okay, but it is a measure, and you come out with a 1, and you could say you support it. I'm just trying to determine what is the actual outcome.
You mean by
Numeric. If it's not 1, it's less than 1, right? Yeah. Does anybody? All right, so that number is not available today. Okay. At this juncture, Mr. Slater, are you still with us remotely?
I am.
All right. Would you mind taking the floor, please, on this issue? Thank you.
Absolutely. And I did hear Commissioner Wheatley's question, and as outlined in our letter of support, this is the first natural gas energy efficiency program in the state. So naturally, there were startup and ramp up periods that were anticipated. Some of the things that weren't anticipated were a software issue where natural gas utility fields could be left unanswered. That was a challenge that we worked through with with our contractors, mostly because the contractors were used to just entering the electric field, since we only ever had electric programs previously. When that was corrected, one of the other challenges came in, which might be a good challenge, is negative gas savings. So we've seen a lot of electrification. Home Performance with Energy Star, our flagship award-winning program, uses the whole house approach. So when you replace your HVAC, like our significant increase in mini splits and heat pumps and heat pump water heater utilization, it shows negative gas savings. At the time of approval at the EEAC, there was no model calculation to input where we could have potentially calculated natural gas savings if the system had remained in place versus the new system. And so we weren't, we can't then, bill Chesapeake for negative gas savings. So that was a significant challenge. Just the fact that we've seen mini splits, heat pumps, and heat pump water heaters just take off, as well as some other programs that show negative gas savings. We also just sort of limited our opportunities for gas savings. That is a lesson learned going forward and certainly into the next 3-year period. And I agree, we absolutely need more participation. And so, we're working on getting more participation. The Delmarva Power Customer Relief Fund has been wildly successful, more than 10,000 customers. And it goes back to really the software issue. And, I take some blame there because I should have spent more time with our contractors, making sure they knew to fill in the gas utility. There's also the issue of a lot of Chesapeake customers don't know what their account number is. There's not like a My Account feature. And so that was also challenges. We've worked to correct a lot of those. We've worked to create mapping so we know their service territory. And hopefully that helps to address your questions, Commissioner Wheatley.
Thank you, Mr. Slater. I appreciate that input. Any other commissioner have more comments on this matter? I don't know if the public advocate has any comments or a witness in this matter.
We do not have any witnesses, but do you have any? No comments.
Okay. So I think I heard staff indicate that there is a criteria for approving this program, and by statute, has not been met. Did I hear that? Yes? Okay. All right. So that leaves us a little bit on the fence in terms of exactly what we should do in moving forward on this matter. So I'd ask if commissioners have any thoughts on which of these orders to actually put forward for approval.
Gray, I have thoughts. I'm sure that comes as no surprise.
Please, you've got the floor.
I believe that we should vote for staff's version of Order 11054. Let me first say that I have nothing against energy efficiency programs. I think, as we've often heard, the cheapest megawatt is a negawatt. And in this case, of course, it's a therm. But these programs were implemented pursuant to specific statutory requirements set forth in the Delaware Energy Act, which is Title 29, Section 8059H. Subsection H1B of that section makes clear that the programs must be, quote, cost-effective, reliable, and feasible, end quote. And subsection H1E of Section 8059 explicitly states that the commission shall approve for cost recovery for cost-effective energy savings resulting from cost-effective programs and portfolios of commission-regulated affected energy providers that are verified through procedures established in regulations promulgated pursuant to paragraph H3 of this section and determined not to increase overall utility bills. Now, DENREC promulgated such procedures as regulations and established the total resource cost test to measure the cost effectiveness of energy efficiency programs. The record is clear that the programs don't satisfy the total resource cost test as set forth in Staff Witness Marshall's memo and as confirmed by Chesapeake. These programs didn't come anywhere close to breaking even, let alone being cost effective. And nor, based on the statistics, does it appear that the programs will achieve the participant level in year 3 that would be necessary for them to become cost effective. Now, I realize we're not talking about a lot of money in the grand scheme of things, but we just voted to approve a huge increase in the price of natural gas supply that Chesapeake ratepayers are paying and will continue to pay. And that cost, as you've heard, is an automatic pass-through. We don't have any discretion to reject those actual supply costs if they're verified. Now, one thing that used to bother me when I was representing staff and the public advocate was when the commission would listen to all my arguments about why it shouldn't approve some new program a utility wanted to implement and then would approve it because, well, it doesn't really cost that much. But these things add up, and pretty soon you're talking about real money. As for the SEU's letter and the SEU's statements today, I respect Mr. Slater. Everybody knows that. But I don't give that letter or his statements any weight. The SEU isn't a party, so the letter is nothing more than a public comment. To the extent that the SEU thinks the program should be continued, it can pay for all of them. And I noticed that it has offered to do so. Let's take it at its word. I go back to section 8059 of Title 29. Subsection A provides that the programs approved by the EEAC and submitted to the commission, quote, shall be designed to maximize the cost-saving benefits for ratepayers by utilizing private financing and allowance proceeds from the Regional Greenhouse Gas Initiative to the maximum extent practicable, consistent with this section, as the preferred sources of program financing prior to expenditures that would otherwise be eligible for rate recovery. The SEU gets the lion's share of RGGI funds, so let it pay for the programs. That would be most consistent with legislative intent. Since these programs don't meet the cost effectiveness test that DNREC has established for them, I submit that the application should be denied, the programs should be discontinued, and again, if the SEU wants to continue the programs, let them do it.
Thank you, Commissioner Iori. Any other commissioner have a comment on this matter? All right, hearing none. I'm looking now at the same proposed order, 11054. One is denying and the other is approving. And I'm seeking a motion on one of those orders.
I move to accept, or I move that the commission approve order number 11054 as submitted by staff.
And that is the order denying the rate increase, Commissioner?
That's correct. Denying the rate as final and discontinuing the programs.
Thank you. Do I hear a second? I do not hear a second from.
Mr. Chairman, I will reluctantly second the motion because on the law, the order stands in my mind. As much as I am disappointed that the programs did not work out the way they were supposed to, and but the law is what law says. What the law says, and in this case, in contrast to the one we had earlier, to me it is quite clear in this case. So I will very reluctantly and disappointingly second it.
Thank you, Commissioner Wheatley. It has been moved and seconded that the commission adopt order number 11054 denying the energy efficiency rate increase that went into effect and requesting the programs be discontinued. Any further discussion amongst the commissioners?
Mr. Chairman, can I just, I had a hard time hearing some of the testimony from staff. And so I heard that the program does not meet the TRC requirement of 1.0, and you asked several questions about that. Did we ever get a number for how far below it is below the TRC, or is that a calculation that just isn't available to us today?
I sought that specific number, and it is not available in the hearing at the moment. I would hope that if it has been calculated and determined that it's deficient, that we as a commission could be informed exactly what that number is. But I furthermore asked Commissioner Richard whether or not this was a statutory requirement that it meet a minimum of 1, and the response was yes. And I think that Commissioner Wheatley's second to the motion reflected on the fact that it doesn't comply with the statutory requirement.
Okay, so that's what you heard there clearly in the word. I guess what's in my head, I don't like denying these programs, and if it's the basis on just exactly where we are and how far below it is the 1.0. Is it necessary for us to make this decision today, or is that number we can get in the near term?
Well, if it's black and white in terms of it does not meet the statutory requirement, then that for me says I would be inclined to support the motion as it stands.
Okay.
So
yeah, I guess my concern was it sounded like there was just some, I'm not sure where the tolerance is and how precise this is calculated. So, okay. Yeah, that's just sort of the disadvantage of not hearing that fully. All right. Well, thank you, Mr. Chairman. Those were my only discussion questions.
Thank you, Commissioner Richards. So it's been moved and seconded that we adopt this order 11054 denying. At this point, we'll take a vote. All those in favor,
Sorry,
please.
one more question. Is this without prejudice, or are we denying it permanently? I mean, could we perhaps amend the motion to deny without prejudice?
I'm going to yield to legal on that question, Commissioner.
This is Kate on behalf of staff. The program would only run, to my understanding, through the end of the year, and then they're proposing a new set of programs for beginning in 2027. So the 2027 is kind of when they'll have another bite at the apple, so to speak, on this type of program. This is just discontinuing the program for the remainder of the year.
Okay, thank you for that clarification. Thank you.
All right, thank you, Commissioner Richard. So now we'll take a vote. All those in favor of the motion, please signify by saying aye.
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 Aye. Commissioner Richard.
No.
So the commission has 3 ayes, 1 nay, and 1 recusal or abstention. And so the order is adopted. Thank you very much, everyone, for your input on this matter. Thank you, Mr. O'Brien, Mr. Weiss.
And commissioners.
Ms. Marshall, thank you. Okay, the next item on the agenda is in the matter of the adoption of rules and regulations to implement the provisions of 26 Delaware Chapter 10 relating to the creation of a competitive market for retail electric supply service, PSC Regulation Docket 3001. And I think, Ms. Workman, I'll turn to you to open this matter.
Yes.
And Commissioner DePrima is rejoining the panel. Thank you, Commissioner. Welcome. All right, Ms. Workman, please.
Today's hearing is for the commission to hear comments relating to the proposed amendments to 26 Delaware Administrative Code 3001 that were published in the May 2026 Register of Regulations. This has been a process that's been going on since early 2025. So I'd like to give just a brief overview of what has happened thus far to get us to where we are right now. In response to customer complaints from high energy bills in the first 2 to 3 months of 2025, the Commission opened Regulation 3001 to improve the regulations, hoping to provide better customer protections. And they were opened in April of 2025. Staff conducted a workshop with interested stakeholders to get their input into the regulations. However, we received no proposed changes at that time. The amended 3001 regulations were published in the October 2025 Register of Regulations. After that, Delmarva Power filed some comments to improve the customer experience relating to notice requirements in particular. Staff made substantive changes to the regulation based on those comments, so we had to republish. And that was republished in the February 2026 Register of Regulations. And then we got more public comments, this time from the Retail Energy Supply Association, or the RESA, and staff again recommended substantive changes to the regulation as a result of those comments. The third round of revisions, which is the one we're on right now, was published in the May 2026 Register of Regulations, and today is the required public hearing on the regulation. The Commission has received 2 written comments, both on July 8, one from Delmarva Power and one from RESA. And I'm going to give you a summary of both of those. The individuals who filed them, or the parties that filed them, are welcome to speak to them today, but if not, they've been presented for you to examine and I'm going to give a brief summary. Delmarva Power commented that they recommend a non-substantive change to properly identify the Division of the Public Advocate. Right now it reads as the Office of the Public Advocate. They also recommended clarifying that a 7-day notice period that we added in previous rounds of amendments be changed to, well, just to clarify that the 7-day notice period begins upon the utility's acceptance of an enrollment request, which would give the suppliers sufficient time to confirm the enrollment. RISA's comments generally supported the changes in the third version of amendments and requested that staff amend a portion which contained an error. And they also requested an implementation period of at least 75 days in order to implement the new rules, because the new rules would significantly change the notice requirements that the third-party electric suppliers would have to go through with their customers. At this time, I would like to ask any members of the public who have come today to comment on the proposed regulation to step forward and then share their comments with the commission. First, I'm going to ask for comments from people in the room. If anybody on Zoom has comments, please select the raise hand feature on the Zoom platform so that we can identify you in a minute. Does anyone in the room have comments they would like to make? Please identify yourself for the record.
Good afternoon, Chairman, Commissioners. My name is Eric Wallace. I'm with the law firm Green Herlocker, here on behalf of the Retail Energy Supply Association. Mr. Green filed comments for RISA on July 8th, and I think that staff counsel gave an accurate and concise summary of the comments. The key things that RISA is asking for are a clarification. There was a scrivener's error where there was a duplicative statement that we wanted to clarify. So that's accurate going forward, as detailed in the comments. And then we're asking for a 75-day period, effective date from the approval of these regulations to allow the suppliers to modify their systems, implement the processes, and train their folks internally to make sure they're in full compliance when the regulations take effect. And that is consistent with the timing the commission used for the last significant overhaul of the regulations a few years ago. Happy to answer any questions, but those are our requests. Thank you.
Thank you, Mr. Wallace. Go ahead, Ms. Brickman.
Did anybody have questions for Mr. Wallace? Okay, thank you, Mr. Wallace. Do I have anybody else in the room who would like to provide public comment? Go ahead.
Thank you, Ms. Workman, and thank you to the staff's efforts to.
Can you please identify
I
yourself?
apologize. Zishang Shen on behalf of Delmarva Power. I'll just be very brief. Ms. Workman accurately summarized our comment and that we submitted for the commission's consideration, and we do appreciate staff's continued efforts to make thoughtful amendments to this set of regulations. And I just wanted to our comment is, I don't think it's super substantive. It was mainly to clarify the one section in section 11.6, where it sets a 7-day window for the suppliers to provide a written notice to customers who've elected to switch from Delmarva to a retail supplier. And so we just offered a suggestion that the 7-day window be established when Delmarva has provided to the supplier confirmation of the enrollment. So currently, as the process works, a customer signs up with the supplier then sends the enrollment request to Delmarva via a platform called the Electronic Data Interchange. So it's an electronic platform, and then on the Delmarva side, we confirm, the customer, it's a current account. and then send back the acceptance to the supplier via the platform. My understanding is that that process generally takes maybe a business day or two. And so then our recommendation is just to kind of have that clarity within the regulation that the 7-day window for the supplier to then provide notice to the customer starts when they receive that confirmation from Delmarva. I think it should provide some sense of clarity to the suppliers as to when that window opens. So hopefully that is helpful.
Any questions from the commissioners? Anyone else in the room have?
Ms. Workman, I think Commissioner DePrima. Yes?
I'm going to be bluntly honest here. This is a public hearing. I have no idea what anybody's talking about. And we got no background information. There was no staff memorandum on this. The comments that we did get came late. We're new commissioners here, folks, and I'm talking to everybody, all the people who are generally in front of us. We're new commissioners here. You can't do this to us. You need background information. I need to know what I'm supposed to be listening to. It's not happening. And this isn't the first time, but it's the first time I'm speaking about it. So I'm going to ask everybody going forward that we please understand that you need to explain stuff to us in plain language. We're not attorneys up here. One of us is, you know, and it's getting a little frustrating for me. So I'm going to ask somebody, what exactly is this rule and regulation? What was its intent? What happens next? We're having a public hearing. I'm sitting here listening to it. I don't know what the next step is and what we're doing. So could somebody just explain to me what these rules were about and why were they done and what the purpose was? I'm sorry to be blunt, but that's the way I feel.
Thank you, Commissioner. So first and foremost, I would say you'll note here that this item was added after the initial posting date at the request of staff. And Ms. Workman, would it be a good assumption that some matters make it to our agenda because statutory requirements have date stamp necessity for the commission to act, and they may occur within the time range after the full notice has taken place. But I certainly give due consideration to Commissioner DePrima's frustration to expect to understand the matter in which we're addressing. And so perhaps you could take a few moments just to give a level setting in the context of what this matter is related to.
So first, regarding the process, like I said, these were published before, I believe, the new commissioner started. This is our third round of publications. The regulation is regarding third-party electric suppliers, and it is the regulation that tells them how they have to treat their customers, essentially. And after the cold snap in 2025, where customers saw giant increases in their bills, there was I'm going to call it a task force where members of various groups got together to try and figure out why are the prices so different? Why are people's bills so much higher in the winter? And one of the problems they identified was third-party electric suppliers. And in that investigation, they found that a lot of people who have third-party electric suppliers don't necessarily know they have a third-party electric supplier. So one of the big things that we wanted to correct in these, what is supposed to be customer protections, are notice requirements in particular about how customers hear about that they are enrolled in these programs, because these are programs that, I don't know, I've run into people in the Sam's Club and the Walmart asking me if I'm a Delmarva Power customer and trying to sell me third-party electric supply. And so you may sign up and then you forget or you don't know, and then you end up with a bill that you don't understand because now there's a third-party electric supplier on it. So the goal was really to provide better notice to customers when they sign up for these third-party electric supply companies, and then better protect the customer is the goal that we're trying to accomplish. Next steps. So today we're just having the public comments where the commission hears the public comments. In order to be included in this public comment session, written comments need to be submitted 7 days ahead of time. So the public comments we received were submitted July 8th, which is 7 days before today. They were not initially, so while the initial agenda did include this hearing, the public comments were not included because staff didn't get them until the day you got the agenda. And so, we will try and do better moving forward to make sure that public comments are identified before we finalize the agenda to send it to everyone. And then, today is when the commission gathers these comments. And then at our next meeting, the public comments period is going to remain open for 15 more days. And at our next meeting, the commission is going to discuss what they want to do next. So if we want to have a final order adopting the regulation as amended, if you would like to have if we would like to make more changes to the regulation, if we need to make substantive changes, we would have to republish it. If they're not substantive, we don't have to republish it. And then from there, I would submit whatever the commission decides to the registrar who run the Delaware Register of Regulations, and they would publish it as soon as I submit it. Well, not as soon, the month after I submit it. Would it be okay if we address the questions after we close the public comments?
Sure.
Does anyone else in the room have any public comments to make? Is anybody on Zoom would like to provide public comment?
Ms. Workman, just before you move forward, I want to just clarify, Mr. Wallace, right?
Yes.
Okay, Mr. Wallace is here from RESA, and these acronyms are going to be frustrating for some of my newcoming commissioners, but I believe that's Retail Energy Suppliers Association. Am I right?
That's correct.
Okay, and one of his colleagues has sat in that chair in a previous review of the editing for these regulations. And so he's obviously maintained an interest to continue the public input from his association, which I would assume represent many of the brokers that will have to comply with these regulations once they are put into place. Did I get that right?
Yeah, the members of the Retail Energy Supply Association are licensed retail suppliers that are serving customers in Delaware, and they're going to be implementing these requirements, particularly the notice requirements that are kind of the core change here. And so that's the interest that members have in this proceeding and in providing the public comments.
Okay, but when the statute requires that regulations have to have a public hearing, this is why we're here in this forum, and Ms. Workman has been working us through this process. So I'll yield back to Ms. Workman at this point, please.
Thank you. I don't see anybody on Zoom who wants to provide public comment. Pursuant to 29 Delaware Code 10118A, the public comment period will remain open for an additional 15 days, and written comments will be accepted by the commission. The commission will deliberate on all comments received at its next regularly scheduled meeting. Thank you. That concludes this public hearing on 3001.
1 second, Commissioner. Any comments from the public advocate on this matter?
No, thank you.
Right, thank you. I think Commissioner DePrima indicated he may have some questions.
will we actually see the regulations? Will we only see the final draft, or are we going to get some history as to like a markup document with comments as to who made the change, who agreed to the change? Well, you know, when are we going to see these regulations so we can understand it?
I can send them to you whenever. I can send them to you when I get back to my office. I can send you the different iterations that we've submitted over the last year and a half, so that you can take a look at how they've changed. And then the public comments are entered in the Dello file system, so you can find them there. If you want to find them, you type in for the docket number reg period 3001, and then that will take you to the correct regulation docket.
But at some point, I hope we get some orientation on how we even do that. I have no idea what you're talking about in terms of going to some. So I'm glad that we'll get them in advance. I guess that question is why a year and a half? This is an important issue. I remember at Energize Delaware, we used to get people complaining about this issue, and there's nothing we could do about it. So we would refer them to the public advocate, I guess, usually my recollection is. So why does it a year and a half take care of it? I think it was a pretty important consumer issue. People really felt like they were getting ripped off.
Yes, and we agree, but there's a process, that a statutorily defined process that combining from the APA, the Administrative Procedures Act, in 29 Delaware Code, which requires publication in the Register of Regulations, and then 26 Delaware Code. I don't remember which one in particular, but they require the commission to have a hearing on all of their proposed regulation changes, and those hearings have to be noticed 20 days in advance. So by the way that the meetings have worked out, sometimes it takes longer than 20 days. Sometimes it takes, never takes less than 20 days, but sometimes you're waiting, a month or more to get to a commission meeting. And the beginning of the process wasn't as fast as it could have been because we tried to solicit input from stakeholders before we submitted for initial publication. We held a workshop, and then we didn't get the participation that I think we may have hoped for. And then we've had to republish several times, which means we have to have this long period. So you have a publication, a 20-day notice period, a hearing, a 15-day period where the comments remain open, and then you have to have a meeting where everybody discusses it, or the commissioners discuss what amendments they want to make, if they want to publish, what the next step is. So this is the third time doing that long process, in addition to, at the beginning, taking extra time to try and do it right the first time. So this is abnormally long.
That's fine. Looking forward.
Mr. Chairman.
Just a moment, Commissioner Richard. I think Commissioner Iori had her hand up before yours.
Okay.
Commissioner Iori?
Thank you, Chair Gray. Commissioner DePrima asked one of my questions, but just to follow up on that, Commissioner DePrima, part of the biggest problem here is the time frames that are set forth statutorily. It would really be nice if we could get the APA amended and maybe the Public Utilities Act amendment amended to reduce the amount of time in between things. But I mean, especially now that things can be done via email and, communications are much quicker than they were when these things were passed. But unfortunately, it's a function of the statutory provisions.
Thank you, Commissioner. Commissioner Richard?
Yes, Mr. Chairman. As you know, we communicated a little bit about the whole retail choice, where it stands in Delaware, and some of the questions I had. It sounds like maybe we all have some of these same questions. So perhaps this might be something we can add to a future regular meeting. Maybe just a briefing on the bigger picture of retail choice, and then also getting into some of the proceedings. I did have to dig in today, so I understand where Commissioner DePrima is. I was trying to figure out what exactly we were doing today, but it wasn't apparent to me at first. We were just having a public hearing on the regulations that's commented, but these issues of slamming or unauthorized enrollment are pretty big, and they're also things that are being addressed in other states, Maryland, Massachusetts, and really kind of as they look at their programs. So in any case, I was just going to suggest that rather than just me having a one-on-one with staff, perhaps this might be something worthwhile having in a public setting at one of our meetings, just to.
I think that's a good idea. I'm getting a thumbs up from Executive Director Hardigan, and I do think, while we're on this subject, that new legislation has actually come out of Dover that's going to also impact yet another revision on the rules. And I see people shaking their heads, and I'm not really interested that we dig deep down to the details. But the fact is that as we're finishing off this revision, there are new ones coming. Okay. Ms. Workman, what action does the commission need to take at this juncture?
At this juncture, the commission does not have to take any action. We will bring this up again at the August 5th meeting.
All right. Thank you very much, everyone, for your input and for the questions. And so that concludes the hearing part of our agenda. And the next are administrative matters. Mr. Hardigan.
Thank you, Chair Gray. Before I turn things over to Lori Murphy-Lee from PJM, I just wanted to note that we were going to have an OPSI overview with Commissioner Richard, but we'll postpone that to a future meeting. So, yeah, I would like to invite Lori up to give us a PJM 101 overview.
Okay, thank you. And while Ms. Lee is coming up, Commissioner Richard?
Yes.
Just a quick question. I didn't know whether you wanted to continue to join us for this segment of the meeting. I know that you're probably fairly familiar with PJM.
I'd actually like to sit in and hear what the latest presentation is, and it might also help inform some of the discussion I might be able to lead when we discuss OPSI. So if it's not an
fair enough.
inconvenience, if it's not an inconvenience, I'd like to stay on.
Yeah, no problem. I just wanted to know whether or not you wanted to bail. All right. Thank you very much. Mr. Hardigan.
If I could, thanks, Commissioner or Chair Gray. So we are having a little technical issue in terms of displaying PDFs. So Kendall is bringing this up through her email. So Lori, you'll just have to tell her when to advance.
Okay. I will do that. Can you all hear me? Go closer. Is it better?
Welcome, Lori Lee, PJM. It's good to have you here.
Thank you so much, Chairman Gray. Good afternoon, commissioners. Thank you, Chairman Gray, for inviting me to speak today. I'm going to give a high-level overview of PJM, who we are, what we do. I will try to pause at the end of each slide, but if you have questions, please feel free to just interrupt me, okay? First slide. Okay. Oh, right, that's slide 2. No, you're right. No, you did it right. But I said first slide, so that's why I wanted to correct it. Okay. So PJM is a regional transmission organization that's part of the Eastern Interconnection. This map shows where PJM's service territory lies within the Eastern Interconnection. The United States has 7 RTOs, of which PJM is the largest. PJM represents 26% of generation, 25% of the load, and 20% of the transmission assets located within the Eastern Interconnection. Also, 21% of the U.S. gross domestic product is produced within PJM. You can see additional statistics about PJM listed there on the slide. I won't read that. PJM serves all or part of 13 states and the District of Columbia. Next slide. Slide 3. Sorry. Which slide? Okay, sorry. This slide is just a larger picture of our territory where you can see the individual states a little bit better. Even though a portion of the grid to the west looks like it is physically separated, this territory is actually connected to the rest of the system. Slide 4. So what is a regional transmission organization? PJM's role as a regional transmission organization is to ensure the reliability of the high voltage electric power system, which essentially means we're responsible for keeping the lights on in the 13 states and District of Columbia. We're responsible for directing and coordinating the operation of the transmission grid within our footprint to make sure electricity flows to where it is most needed. PJM operates several types of competitive wholesale markets through which large volumes of electricity are bought and sold across our footprint. The markets support our mission of reliability at the lowest possible cost by giving financial incentives and encouraging competition to provide electricity when it is needed. We plan our transmission expansion improvements to the regional transmission system to maintain the reliability of the grid and to relieve congestion. As an RTO, we own no transmission or generation assets and have no financial interest in the wholesale market or in any of the market participants. Slide number 5. So distribution of power. I want to emphasize that PJM is different from your local utility. We are an independent, profit-neutral organization and have no shareholders. However, we are regulated by the FERC, the Federal Energy Regulatory Commission, much like many of your utilities are regulated by the State Commission. We operate the bulk electric transmission system, which ensures that large amounts of power are efficiently transported over long distances, regardless of who owns any particular power line, per our agreement with the transmission owners for operational control of the transmission system. You can see from this slide that PJM is in the center. We are the ones who are directing those generators where to send the power onto the transmission system to keep the flow of energy going. Generated power is stepped up to high voltage levels for the transmission system, and then when electricity reaches substations, that electricity is stepped down. So those bigger, taller transmission lines are the wholesale part or the bulk electric transmission system. And then the smaller ones that you see represent the distribution system. So those are the poles and wires that connect to people's homes. We do not directly serve any end-use customers or retail customers. Although we coordinate maintenance of generation and transmission systems, we don't perform any of the maintenance, nor make any business decisions about how the generation is sustained. Okay, slide 6. So I'd just like to take a minute or so here to delve more into the specific role as an RTO. So at PJM, we focus on 3 things: planning, operations, and markets. We plan the transmission system, much like an urban planner, proactively designing for the future. We plan our transmission grid through our Regional Transmission Expansion Planning Process, or RTEP for short. We plan the transmission system in yearly and 5-year increments out to 15 years by assessing the need for transmission upgrades to ensure reliability of the system. Operations. Operations is where PJM matches the supply of energy with the demand for energy to ensure reliable grid operations and the resiliency of the grid. Our operation of the grid is similar to the role of an air traffic controller. Just like an air traffic controller, we don't own the equipment we direct, but we ensure that needed energy is directed where it should go by keeping the system balanced. We operate our system for safety and efficiency using SCED, that's Security Constrained Economic Dispatch, which enables the lowest cost by optimizing the system to utilize resources on the grid in the most cost-efficient manner. We are constantly balancing the need to make sure our system is reliable as well as efficient. Our third major role is the operation of competitive, fair, and transparent markets for large blocks of electricity. Similar to the way the stock market works, our markets are internet-based. PJM runs an energy market, capacity market, and ancillary market. Each market serves a separate function, but they work in tandem. Next slide. It's number 7. This map shows the different transmission zones. PJM was founded in 1927 with just 3 states, Pennsylvania, New Jersey, and Maryland. You can see how it has grown over the past 99 years. You can see that Delaware and DC are the only states that are within 1 transmission zones. Most of the PJM states have more than 1 transmission zone. Slide number 8. So earlier I mentioned that like urban planners, PJM plans the transmission system in our footprint through the RTEP process, looking 15 years forward. Published annually, the Regional Transmission Expansion Plan report summarizes studies that help ensure the system meets requirements for reliability, market efficiency, resilience, public policy, and the needs of the transmission system owners. The planning process is conducted through an open engagement with members, stakeholders, regulatory agencies, and other parties. We are constantly planning to eliminate congestion, and we do not operate any power lines below 100 kilowatts, as those are strictly left to the distribution company to operate and plan for. This map shows the backbone of the PJM transmission system, substations and power lines at 345 kV and above. While there are lots of transmission lines between the 100 kV and the 345 kV that PJM does operate, it would just, be too difficult for the map. It would crowd it so much it wouldn't be valuable for you to see. But basically, without transmission, electricity would have to be produced close to where it's used. The transmission system is an essential part of the bulk electric system. A robust transmission system gives different geographic areas access to power from distant generators, regardless of their location. Now, I just mentioned how PJM is constantly planning the transmission system, in large part looking to relieve congestion. While congestion can affect reliability, it is more so an economic concern. To illustrate what I mean, I want you to think about riding in a metered taxi cab. If you make a trip when there's very little traffic, then you will arrive to your destination quickly. However, if you travel during rush hour or get stuck in a traffic jam, not only will your ride take longer, but it will cost you more because your meter continues to run even though the car is not moving. Additionally, I will mention that there are new guidelines from FERC per FERC Order 1920 regarding the planning of long-term transmission build. And we have appreciated working with you all of our states, to make this filing. So we very much appreciate the input from the states. Slide number 9. So this just shows the 345 kV and above lines with an up-close snapshot into Delaware. As you can see, Delaware does not have any 345 kV or 765, just that 500 line. Slide number 10. Now, I'd like to share a little bit about PJM's structure and governance process. So PJM operates through a two-tiered governance model that functions neutrally and independently. The PJM Board of Managers consists of 9 voting members and the PJM CEO. Board members may have no relationship with nor financial stake in any PJM member. The board ensures that PJM fulfills its business, legal, and regulatory obligations while running a safe and reliable grid and operating fair energy markets. You will see next to the independent Board of Managers the Market Monitor, often referred to as the IMM. The Market Monitor is independent of PJM staff and members and is responsible for guarding against the exercise of market power in PJM's markets and assisting in the maintenance of competitive and non-discriminatory markets in PJM. PJM has over 1,000 members. Members must qualify for at least one of 5 sectors: transmission owner, generation owner, electric distributor, end-use customer, or other supplier. Members take part in PJM stakeholder process, which provides a forum for those with a stake in the wholesale electric industry to engage on a variety of important issues. Members vote through our stakeholder process, and although members might qualify for multiple sectors, they must choose one to vote in, as only 1 vote per member is allowed. Membership is required to participate in the markets and to access other key privileges, but not all members are market participants. Slide 11. So every January, PJM issues its long-term load forecast. This load forecast confirms the trend of significant growth in electricity demand over the next 20 years, albeit with a slight decrease in the expected load growth for near-term years compared with last year's report as shown on the graph. I don't know if you all can see that little dip of the dotted line that goes out to the 2026. You can see early on it dips and then it goes back up. So it is worth noting that the latest forecast still includes substantial demand increases when compared to the forecasts issued just a few years ago, showing how quickly these industry dynamics are accelerating. And this demand increase in PJM is being driven primarily by data center proliferation as well as electrification. Forecasting the demand for electricity across the region is an important part of PJM's mission. Our long-term forecast is used in planning the capacity market and the regional transmission expansion plan. PJM's short-term forecasts are regularly used in maintaining day-to-day reliability of the system and in power market activity. Many factors are considered in PJM's forecasts, including weather, economic activity, and end-use trends. Slide number 12. This shows PJM's existing installed capacity, which I like to refer to as PJM's steel in the ground. So these are the resources that are existing and operational today, which are needed to participate in the PJM capacity market. These are the resources we count on for reliability. You see up there, it'll say CIRs. So generation resources must have capacity interconnection rights. And these are essentially the rights to input generation as a generation capacity resource on the transmission system at a specific point. Slide 13. This shows Delaware's installed capacity. The existing steel in the ground is overwhelmingly natural gas, followed by oil, and then a little bit of solar. Slide 14. So once again, zooming in on Delaware, you see the summer and winter load growth. Projections, so these projections are representative of the forecasted peak. Delaware's summer peak load is not projected to change annually over the next 10 years, while the winter peak is projected to increase by 0.1%. So driving this summer growth being less than the winter growth include in part behind the meter solar installation. Additionally, you can see that Delaware's summer and winter peak expected load growth are much lower than the RTO as a whole. Slide 15. So I was going to move into looking at large loads like data centers. And you can see here that Delaware's large load adjustments are 0. Delaware has not reported any large load adjustments to the PJM load forecasting process.
Consider large load. What is large load? What's your definition?
So it's 50 megawatts or more. Okay, so slide 16. Okay, I'm going to take a minute on this slide as well. So I explained that PJM is governed by an independent board of managers. The PJM board does have a plan to integrate large loads reliably, and I'm going to try to give you just a wee bit of background to set this up. So on January 16th, the PJM Board of Managers outlined a series of actions to be taken by PJM and its stakeholders this year. This is to address the multiple challenges of integrating new data centers and other large load customers onto the grid while preserving the electricity system reliability and the affordability for the 67 million people PJM serves. The board's announcement represents the culmination of the Critical Issues Fast Path, or CIFP. That is an accelerated PJM stakeholder process, and this process produced 12 proposals. That process began in August of last year, 2025, and it ended in December. The depth and quality of concepts advanced in that process informed the board's decision, which incorporates ideas drawn from multiple proposals. The plan detailed by the board includes proposals to be filed directly with the FERC, changes in PJM's policies and procedures that can be made immediately, and proposed stakeholder processes to inform the board on complex but equally urgent issues. So immediately prior to the PJM board's release, the White House and 13 governors from the PJM states, which of course includes Governor Meyer, issued a statement of principles. This statement of principles focuses on data centers and how they interact with the PJM grid. So now I just will give you, mention very quickly each of these pieces. Am I okay on time?
Going to acknowledge one of the commissioners will need to withdraw at about 4:15. No, just keep going.
Okay.
Thanks.
Thanks. So at a high level, these are the PJM board action items. making significant load forecasting improvements. In terms of large loads, we will be working with our states to ensure that there is not double counting of loads for folks that are in different, when a data center goes around to different jurisdictions. We think that if every state shares what they know and that about individual large loads possibly coming to the state, that then we can cut down on the doubling. As well, they will be able to tell about the viability of the load. And again, these are 50 megawatts or more. PJM has hired a consultant. That consultant will work with our load analysis subcommittee. They will ensure that the data centers are showing financial and construction commitments. These changes will be a part of the 2027 load forecast. Extension of a price cap and floor. Yesterday, the base residual auction results came out. That's for the PJM capacity market. Put in place 2 auctions ago, and then as well yesterday's, was a floor and ceiling. So the highest that the capacity auction would go, $325 per megawatt day, or right around there, depending on the calculation. But that was the result from the auction, is that the price will be $325. Examining your own, bring your own generation and expedited interconnection track. So this is for large-scale resources. These resources would be studied in parallel with our traditional interconnection queue. So this is to bring more resources on the system very quickly. And let me just say, so about 3 years ago now, 3 auctions ago, our the PJM capacity market prices went up like 16 times, like by 16 times. For several years, the prices had been extremely low. We're talking probably, I think the lowest was around 28 megawatt hours per day. It was that low. It then went up to, I think it was, gosh, I can't remember the exact price, but very, very high. This cap and floor have been agreed to. The FERC has approved it. And so the PJM capacity prices will not go above $325 a megawatt day for the next auction, which will occur in December of this year. Normally, the auctions occur every May. They're 3-year forward auctions. But due to working on the inputs and the regulations and other FERC issues, the auction got off cycle. And so some of the auctions were delayed. And so we've been holding more than one per year to try to catch up. And December will be the last one. Hopefully, following in May, we can get back on track. Okay. Any questions? So just wanted to kind of give you a little color around that. So in terms of this expedited interconnection track, this is to bring on more resources quickly. A big part of the explosion of these prices is that there is now a resource adequacy issue, meaning that generation has been going off of the system faster than it has been replaced. So our capacity market worked great for several years. With this shortage of energy, the market is supposed to signal higher prices, right? If there's less of the commodity, you've got to pay more for it. But this was, an astronomical, obviously, price. So we are doing everything that we can to bring more resources on the system as quickly as possible.
Lori, may I interrupt, please?
Yes.
Will you take question?
Of course.
Thanks. So does this cap artificially disincentivize investment in new generation?
So it's not reflective of where the prices should be to incent new build. But, the reality is, and I will get into our review of the markets in 1 second, and I think that may actually help answer the question. But what I will say is, for the markets to work, they've got to be affordable, of course. If folks can't afford them, that's not going to be sustainable. And so while they have worked for many years, this signal was extraordinary. And so we're doing a holistic review of the markets. Does that help?
That's helpful, and I'll pause to see what you're saying about the markets. I'm just going to thank Commissioner Wheatley, who I think has to withdraw, for his presence today. Safe travels. We'll see you next time. Thank you. I do have one other question before I lose sight of it. Now, you mentioned that your board is focused on getting more accurate load forecasts from large load
Additions.
additions. And so that becomes an issue that is important to all of the 13 plus PJM jurisdictions. But my question is, how are you going to basically achieve that high level? I mean, are you getting this from the developers? Are you getting this from the interconnection requests? Are you sharing this or getting it from your state partners? What's your game plan high level?
Okay, so basically, all the relevant state regulatory agencies will have an opportunity to review large load adjustments submitted by their regulated entities and to offer feedback to PJM. Again, we think that each state will develop its own specific rules about how they do that. And I know that the legislature worked on a bill looking at how the commission would evaluate the process for the commission to work with Delmarva and their other utilities to get that information, and then the commission will be the lead point that will work with PJM to ensure that they have the appropriate information and they're sharing it with us.
So it's bottom up from the state into PJM for the most part. Yes?
Yes.
Okay, thank you. That's sufficient for now. I'm sure I'll learn more later.
Okay. Okay. Additionally, we will be creating a reliability backstop procurement. We have already held stakeholder workshops to establish this reliability backstop procurement. This procurement is to fill the shortfall from this previous capacity auction where we got the results yesterday. We were a little over, let me see the amount. I want to tell you. We were short of our reliability requirement by 6,831 megawatts. And that means that the committed supply is less than what would be required to meet our one event in 10-year reliability standard. It does not mean that the lights are going to go out next year. What it means is we're not at that standard. So our reserve margin is at about 14.7%, and that is short of the 20% where we want to be for that 1 in 10-year event. So this backstop capacity auction will be just to fulfill the megawatts needed to meet that shortfall. Additionally, we're working on Connect and Manage. which addresses the curtailment of data centers that do not bring new generation when they come on the system. And essentially what that means is that, we need to ensure that residents are not getting cut off, are not seeing a load shed event before these data centers are. Grandma's not going to be sitting at home with no electricity because of a large data center. So that's essentially what that is to cover. So both the reliability backstop and the connect and manage work streams have been completed through the stakeholder portion. And that was also done through a CIFP, stakeholder process, a quick process. And now they are with the board. And so the PJM board will also make the final decision about what to file specifically for those with the FERC. The last piece, the last board action is a holistic review of PJM's markets. So we recently issued Powering Reliability Through Market Design. And it's a white paper. And this paper basically discussed, how we got into this shortage issue, what is going on with the capacity market, and the dilemma that we're facing with the capacity market and the high prices. And I mentioned before, it's got to be affordable. It's got to work. And so it basically lays out like 3 options to be considered. It's by no means prescriptive. This is really just a starting point. We really have to have these discussions. In fact, we've been having market design workshops. They started June 12th. They'll go through August 27th. There's, in fact, one going on today. Might be over now. But just as I mentioned, the great work that we were able to do on FERC Order 1920, working with the states, we are also working directly with OPSI. And I'm sure Commissioner Richard will talk a little bit more about this, maybe when he does his presentation. But we're working directly with OPSI, and we really do need state input. We thank you so much for being a great partner. But by mid-September, we really do need this input on capacity market reforms because, it's just really critical that we have that partnering and sharing process so that we know what your needs are and how you'd like to move forward. So just wanted to mention that. Slide 17. So this is actually one of my favorite slides. I mentioned operations as one of PJM's major responsibilities. This is a picture of the PJM control room. PJM's team of system operators, they work in shifts 24 hours a day, 7 days a week to maintain that uninterrupted flow of high voltage electricity. So they act as the air traffic controllers of the grid. They're responding to, preparing for, operating through any possible disruption to ensure that the reliability of the system stays intact. So I invite you to come and tour the PJM control room. We'd love to have you. All right. My last slide is this is the PJM app. If you'd like to download it, you can track electricity use, power grid conditions, wholesale power prices in real time. You can look at the zonal map and other data. And you would receive alerts and can see sort of emergency procedure issues as they happen in real time. So I thank you so much for inviting me to speak today. If there are any additional questions, I'm happy to answer them. And also, if you think of any questions later, please do not hesitate to reach out to me. I would be happy to talk with you and answer your questions.
Thank you very much, Lori, for that presentation. On behalf of my fellow commissioners, and I highly encourage them to work with you and to schedule the opportunity to take a tour at the PJM facility in King of Prussia. It's very impressive, and they have a lot of work to do to keep the lights on for the geographic area that they serve. So thank you for being here today. Any commissioner have a question before I turn this back to Matt?
Could I
Yes.
just offer a couple
Mr. Tweedy, please go ahead.
very quick thoughts? I know we're way late on the day. Load forecasting was discussed. So the legislature worked proactively to try and give the commission authority to make sure that our load forecasts are accurate. As was mentioned, this is a bottom-up approach, and getting that number right so that the right amount of capacity is procured and therefore prices are what they should be, not over-procured, not under-procured, is really important. So that was Senate Bill 308 that was passed this year. I just also wanted to highlight, you had asked the question of, is the cap sort of artificially disincentivizing generation? I just wanted to point out that the capacity price at its now capped level is about 1,000% of what it was just a couple years ago. And it's higher than I think it's been in a decade at least. So the price is dramatically high, but if generation is not yet meeting demand, it's not because the price isn't high enough. And that's a price that all customers are having to bear.
I
despite-
just want to say, I think that's an opinion, okay?
The PJM's independent market monitor has confirmed that the vast majority of this increase and the vast majority of all this load growth is large hyperscale data centers. It is not other causes. So, thank you.
And I'll supplement your comments. Thank you for sharing them, Mr. Tweedy. The first concept, I think, around PJM is you have to realize that there are 13 plus jurisdictions in one large pool. And so decisions that are made policy-wise, strategic-wise in other states, estimates that are made on the ground in other states, large load that show up in other states that are still serviced under the PJM umbrella are having reverberation effects even on ratepayers here locally. And so it's a very, very tough issue to dissect and to pinpoint any one single parameter. So it's useful and helpful to know that we've got some eyes focused on it from a number of different perspectives. And I'm hopeful that, we can get the regulatory model in a good way on behalf of the ratepayer ultimately. So thank you for your input. Thank you for sharing. Commissioner DePrima.
So we talked a lot about the capacity markets, but I'm also familiar of the congestion pricing issue. And when you looked at the map on the transmission, those of us on the Delmarva Peninsula are fairly unique in PJM in that we're surrounded by water. And we have very limited amount of transmission lines happening. So I understand the capacity markets are to create incentives for developers to build power plants. What incentives are happening to encourage more transmission construction on the peninsula, specifically to bring more or bigger lines down? Because there was a point in time where congestion pricing was the big issue. I'm not sure where we're at now.
Yeah, so that's a great question. I will tell you that it is very, very difficult to get transmission built. Typically, when we are planning the system, when you're talking about the bulk system, transmission system, and you were talking about that, you saw from the map that lower southern part of Delaware, there were no large transmission lines. So larger transmission lines certainly would help with the congestion pricing. It's a matter of cost, and it's a matter of we develop the system for the things that I mentioned. We have NERC criteria that we are responsible for meeting. So if there are violations on the system, that triggers us to say, hey, we put out a solicitation and say, hey, we need more transmission to make this meet our NERC criteria. But if the state is saying, hey, look, we're tired of these prices, we want more transmission, the state can have more transmission built. Basically, that would be, there would be a special procedure where the state would basically say they would pay for that transmission to be built because of the way that the cost allocation is done. A portion is always socialized across the footprint. But if this were something where, specifically in Delaware, you decided that you wanted to alleviate some of that congestion, then the state would essentially do a state agreement approach. There are other ways as well, but one of the ways is state agreement approach. And you basically, talk with us and figure out what the needs were, what you wanted to do, and say, we're going to fund this, and that could be done.
Principle, that's the cost will flow in the direction of the benefits?
Yes, pretty much is how it's done.
Thank you, Commissioner. Commissioner Iori.
Hi, Lori.
Hi.
What effect, if any, are FERC's recently issued orders to show cause going to have on PJM's proposals that were discussed here?
What order to show cause are you referencing?
They issue orders to show cause to all of the RTOs recently?
For what?
That's what I'm trying to remember. That's why I'm asking you what effect they would have.
I think it was regarding large loads and what the plan was to accommodate that demand.
I think, yeah.
The large load. Is that what you're asking?
Yeah.
The large loaded. Well, we're working on that right now, but
Right, I saw that up there, but I figured that had probably preceded FERC's orders.
yeah, to be honest, I know that they have opened a large load order to show cause among the many that they issue. I can definitely get back to you with details about that, but I'm not prepared to discuss that today.
Okay, so in the interest of time, I don't hear Commissioner Richard logging any questions. Lori, I'm going to thank you again on behalf of the commission for this presentation and ask that you make yourself available for our newer commissioners to get up to King of Prussia when it's mutually convenient. Okay?
We'd love to have them. Thank you so much.
Safe travels. Take care. Matt?
Thanks, Chair Gray. So we'll end today with a brief presentation from Brian Jordan from Delmarva regarding the Customer Relief Fund, and we'll just work from the hard copies that you have instead of trying to work through our technical issues, if that's okay.
Good afternoon, Mr. Jordan. Welcome.
Good afternoon, Chair Gray. Commissioners, may it please the Commission, Brian Jordan on behalf of Delmarva Power, and I'll start by saying it's a pleasure to see familiar faces in new spaces and new faces in old spaces. For Commissioner DePrima, my name is Brian Jordan. I've worked for the company for about 6 years, but I used to be its attorney, and so I was in these seats frequently, trying to convince now Chair Gray and opposing Commissioner Iori on a number of things. So it's great to be back here and to see you all in person. I will be brief. I'm not here to ask the Commission for an order or anything else, but really just to publicize for the public some upcoming opportunities that Delmarva has for customer relief in its service territory. Before getting there, though, I'll give you a brief background on this Customer Relief Fund and what I'm talking about. There are slides, but you have the analog version in front of you. And what I'm talking about here with this Customer Relief Fund is a pot of about $6.5 million that Exelon has contributed to Delmarva, Delaware, to disperse over 2025 and 2026. To help us spread the word, we have partnered with Energize Delaware through the SEU, as well as with the United Way of Delaware. I'll start with the United Way of Delaware. They were given about $500,000 to disperse to eligible customers for these bill credits. And when I talk about the bill credits, if you're an electric customer, regardless of the county, you're entitled to up to $300 in relief if you are limited or moderate income. If you're a gas customer, so we're talking just Newcastle County, you're eligible for an additional $200. And so if you are a dual gas and electric, you could get up to $500. The United Way has dispersed all of its money to customers, leaving the rest with Energize Delaware and the SEU. And with the SEU, what we've done, we've partnered with them to hold these community events. And part of that is the customer will come to the event, check to determine if they're eligible. And as part of that eligibility, they get connected with Energize Delaware to conduct a home energy audit at their home, and they get all of the benefits of that audit. And once that's completed, then they are that bill credit is dispersed to cover the arrears that they have. So eligibility, who is eligible? This is strictly for our residential customers, Delmarva Power's residential customers. You could be a homeowner or a renter. It just has to be a residential customer. And you have to participate in the home energy checkup that I just mentioned if you're getting the funds through Energize Delaware. There are income qualifications. This is not available to every income level, but to limited income households. That is someone who is at or below 60% of the state median income. And if that's the case, you do not need to have a balance on your account. It could be as low as $10 and you would still qualify. For moderate income houses, however, that's between 60% of the state median income and 350% of the federal poverty level. You are also eligible, but there needs to be a minimum $250 balance on the account in order to qualify for this. I do have, if any of the commissioners have questions about what those numbers work out to, I'll just briefly say for limited income for one person, that is 60% of the state median income. That's $3,145. A family of four, $6,048. For moderate income, remember this is 350% of the poverty level, $250 balance. One person is $4,564. Four persons, $9,377. When I took this position, we decided that we were going to kick this off in the summertime when usage is generally higher than the shoulder months. And so that's why we've really kicked it off in July. And so far, we've had two events, both in the city of Wilmington, although we do have plans to get throughout the state. The first one was at the MSK Community Center. That is My Sister's Keeper Community Center. If you're familiar with what used to be the Maryland Avenue Sub Shop, it's right behind there. It's a different restaurant now, but when I pulled up, there was a line out the door, and it turned out that we served 80 customers that night, which was great. I don't have the exact amount of relief that has been dispersed from that event. That usually takes us 2 to 3 weeks to get because they have to run through the home energy audit as well before the money gets distributed, but I'm always happy to provide updates there. That was July 7th, 2026. The next night, July 8th, we had one at the Wilmington Public Library, and frankly, I did not expect to have a lot of participation, in part because it's not within a community necessarily, and it would require people to take public transit or walk. When we prepared this, we had relief to more than 200 customers. That has since raised to over 350 customers, in fact, about 380 customers. It was packed. And in fact, it was so packed, we had to enlist 4 additional customer service representatives to show up that night, set up their computers, and start processing customers. I mean, that's exactly what you want. You know, you want these packed. We planned for a moderate participation. That blew it away, and we were happy about that. And that's why I had this idea to come in front of the commission today, because we have these upcoming relief fund events, and this is the kind of thing where the more publicity that we get out there, the more people show up. And so that means anybody in this room, when they're at home in their communities and they want to say something, or anybody on the line who is listening in, what we have coming up, and all of these events run from 4 to 7 p.m. Of course, if people are in line, it'll go past 7. July 29th on the Route 9 corridor, the Rose Hill Community Center. It's 19 Lamson Lane in Newcastle, 19720. And that's in Newcastle County. July 30th, this is in Sussex County at the Frankford Public Library, 8 Main Street in Frankford, 19945. And then the next one is August 6th, which is at Life in the Word Christian Ministries, 1500 Beaverbrook Plaza, Newcastle, 19720. And then we're also looking to get some events in Kent County. Kent County has been a challenge, however, because of all the municipal utilities. It's kind of like a Swiss cheese between, who we serve and who they serve, and trying to find a central meeting place where we can get as many people in has been a challenge. That said, we have communicated with the libraries and the senior centers there to make sure that they're making people aware that this money is available. You don't have to come to the event. You can call us up. You can call up Energize Delaware and process your application that way. It's just that these events are a great way to get a lot of people in there and process a lot at once. Last thing I'll mention, the program impact. You heard Mr. Slater earlier today talk about that this is wildly successful, and I agree. We have provided about $4.5 million so far to over 12,000 customers in Delaware since 2025. So, it has had a big impact. United Way, I mentioned them earlier. They've been giving grants to more than 1,000 customers when they ran through their money. We still have $350,000 in funding left to disperse. Estimate that could help up to 750 customers. So, as I mentioned, I really just wanted to publicize these three events that are coming up and get as many people there as possible.
Thank you, Mr. Jordan. I'm just curious, is this something we can link to the PSC website in terms of the calendar schedule?
Yes, we can do that.
Yeah, that might not be a bad idea.
Would love that.
I have two questions. One is the 6.5 in funding only for bill credits? Because I note on the last page, it says in grants.
It is in bill credits, and I think those are more lay terms, not as in financial terms. So you do have to have arrears on your bill. It's not like I could say, I'm going to give you $500 because you're a gas and electric company, a gas and electric customer, and as you use it, we'll draw it down. It's for people who have already incurred in arrears.
Right.
So I mentioned, the only limit there is the moderate income. If you qualify there, it's got to be at least $250.
Okay, I just didn't know whether the 6.5 was paying for program costs and for grants for audits at homes and things of that sort, but it's all bill credits.
I believe that is correct, yes.
Okay, and one last question. Do the recipients need to own the meter?
I think the answer is no, as long as they are the account holder. And that's, I don't want to confuse those because I'm thinking of tenants, right? And particularly if rent.
Oh, my.
Yeah, if rent is part of your, I'm sorry, if the utility bill is part of the rent, so the landlord pays it, it's a real challenge. Because at that point, it's like, and this is unfortunate to me because I represented a lot of tenants when I was in private practice. If that tenant is paying the landlord $100 in rent and $50 in utility, and the landlord's not paying the utilities, it's going to get cut off. Now, the thing is, that tenant does not have the account in his or her name. They would not be getting these credits because it would be up to the landlord to come in and say it's ours. Now, the one thing there, of course, is we've got to also guard against. Balance that out against potential fraud cases where you have, 6 people living in a house all saying we all owe $200, and in reality they don't, and we're dispersing the money without checking to see who the account holder is. So we have, it's unfortunately there is that balance there.
I mean, I recognize the problem statement. I was just hoping you may have found a solution.
I wish I could. One of the companies or organizations I've reached out to is Classy, the Community Legal Aid Society, and I think Ms. Workman may be able to help me with some of that contact to get in touch with their customers and their clients when they're providing advice to tenants that, hey, you might need to think and look at this program, whether you're eligible for that too.
Very good. No further questions from me. Any other commissioner? Commissioner Iori?
This is great. I'm sad there's such a need for it, but it's great that this is taking place. And given what's been happening with utility bills.
Yeah.
You said that the United Way money, the money that they had has already been dispersed?
Correct.
Okay. And did the people who got their credits through United Way, did they have to participate?
They did not.
How come?
It,
Or why not?
Sure. It was, we had negotiations with the SEU about how we would structure this, and they were insistent that we have these home energy audits occur with the money as a way to sort of, I would say, bundle services. We respected that and agreed. United Way did not put any conditions on it, and so they also got about $500,000 as opposed to the rest going to the SEU. And with the United Way, almost the same process, except the customer does not have to go to Energize Delaware. You're welcome.
Commissioner DePrima.
Things with Energize Delaware, they almost have to show that there's some energy savings related to their spending of money. So that's why. But and it does put a burden up because sometimes people just don't want anybody else in their house. And even though these home energy check-ins are not a full energy audit, they don't take very long at all. But it is an extra burden, and sometimes it's scheduling and people work. But I think that's why, to answer your question. My question was, I got confused when you answered Commissioner Gray. So it's a bill credit, but in here it says you can have a zero balance. So how does that work?
The zero balance is the difference between the two income classes, limited and moderate income. So if you're limited income, you don't need to have a balance on, the balance is not a barrier to relief. You could have, obviously, I guess then you would need at least $1, right?
Okay, so you do, there has to be some balance.
Yeah, there's something to.
You can't get zero and then get a credit, so my next bill will be $200, $300 cheaper.
Correct.
Okay,
That's right.
Okay.
That's right.
There has to be something.
That's right. And to the earlier point that you made, Commissioner DePrima, that was, it's like you were listening into the negotiations between the SEU and Delmarva about that in-home issue, because we were concerned, and so was the SEU, frankly, about, would this disincentivize people from signing up for any one number of reasons. You don't want them in the house. Frankly, we're also concerned about, we know what's going on in the federal environment with immigration enforcement, and if that would chill people from signing up. And so we did work it out so that people do have an option to ask that the SEU not come in, but it's left to the SEU's discretion whether to accept that or deny it. So again, it was that balance.
Glad to hear we'll put this on our website. I never check our website, but I follow you on Facebook. I don't know if that's a growing thing, but I just want to compliment you guys on your Facebook posting. So that's really going to hit people.
Oh, yeah. That's all Miss Morris's credit.
Morris, thank you.
Uh-huh.
All right,
I
so.
like it.
Yeah.
All right, so in the interest of time, it's about 4:45. I'm going to yield to Mr. Hartigan. Maybe he can get us out of the room.
Yes, thanks, Chair Gray. Nothing else today. Our next meeting is August 5th.
All right, thank you very much. The meeting is hereby adjourned.